Tomorrow you people are posting a very big program, very big. I know. And yesterday actually that was calling me regarding that program. That is for the entire household, right? So thousands are expected. 10,000, 3,000. You have extra exclusions. Veterinary is veterinary is there. I share it with her, send it to our friends. But I didn't get for you. Comment. Proposal actually satisfied. That is what we are doing. That is hello, sir. Nice meeting you. Yes, sir. And these are the Please have a seat, sir. Yeah, your auditorium is ready. So, what time? 9 o'clock. So, our letter is coming. Protocol issues.
Good morning, ladies and gentlemen. May I request you to please take your seats. We are about to start the program. Good morning again. I would like to invite all of you to please take your seats. We're about to start the program. I welcome our Senior Associate Niranjana, who will be emceeing the whole day session today, to take the mic from here. Thank you.
A very good morning to all of you. On behalf of Surana and Surana International Attorneys and Vinayaka Mission's Law School, I extend a warm welcome to all the dignitaries, luminaries, guests and invitees of this National Conference on India's New Criminal Laws. The phrase transforming justice tells us that beyond enactment of these laws, there's going to be a lot of reorganization and restructuring in the judicial ecosystem. Today we have with us speakers representing various stakeholders and important players in enforcement of these laws. We have judges, lawyers, academicians, officers from crime investigation and prevention, professors from forensic medicine, toxicology, etc. They are all here to give us varied perspectives of the effect these new laws are going to have on us. On that note, I now request Dr. Anand Padmanabhan, Dean, Vinayaka Mission's Law School, to deliver the welcome address.
Honorable Justice K.N. Basha, Justice Vimla, who arrived, Dr. Vinod Surana, all our esteemed speakers, heads of various institutions, eminent practitioners, faculty members, dear students, and all my friends and colleagues. It is indeed a pleasure for me today to come here and address about something that is very, very transformative happening in our legal and criminal justice ecosystem, which is the new criminal laws which have to come into force on July 1st. The tussle between crime and punishment, as we know, is a long-standing one, and it is always a moot question as to when crime and punishment end and redemption begins. I'm sure all of us are familiar with Victor Hugo's famous novel, Les Miserables. It's a very, very interesting sentence there, or a phrase that Victor Hugo had used when talking about this book to his Italian publisher, which captures the universality of this particular theme, right, across borders. And I quote here, he says, "I don't know whether it will be read by everyone, but it is meant for everyone. It addresses England as well as Spain, Italy as well as France, Germany as well as Ireland, the republics that harbor slaves as well as the empires that have serfs. Social problems go beyond frontiers. Humankind's wounds, those huge sores that litter the world, do not stop at the blue and red lines drawn on maps. Wherever men go in ignorance or despair, wherever women sell themselves for bread, wherever children lack a book to learn from or a warm heart, Les Miserables knocks at the door and says, 'Open up, I am here for you, unquote. The reason I quote this book, which is very close to my heart, is that it captures challenges of a certain time which extend to where we are today. It captures the struggles of the criminal justice reform system to always grapple at striking that balance between individual rights, the struggles of a society, and the state's desire to provide for collective freedom. And because this matter is so serious, is so central in many ways to our existence, the procedure by which we spell doom on our brethren, by which we decide that somebody needs to be incarcerated or not, that too assumes tremendous significance. As eloquently stated once, procedure is the handmaiden of justice. So then we have to ask ourselves important questions like whether the procedure is fair yet efficient, whether it is committed to the principles of natural justice that we imbibe in our consciousness from the time of the Magna Carta, or the idea of dharma, which we see in various stories of the just and righteous kings of India that many of us have grown up hearing. And at the same time, that the procedure is one that draws from modern practices and particularly technological potentialities. Finally, of course, does the procedure protect individual rights while securing collective interest is for all of us to think about. Moreover, all these debates and the framework that they ultimately lead to, there is a big question of whether these are culturally rooted. I spoke about the theme of universality, but equally important is the question of whether the frameworks that we have, be it the crimes or the procedures that we apply, whether they are culturally rooted enough. And this is a very important dimension when we explore criminal laws. Be it matters to do with the practice of euthanasia, matters to do with the use and distribution of substances, matters to do with betting and gambling laws, or in any other situation. So that whole tussle between universality and cultural specificity is one that any criminal justice reform will have to engage with. So for all these above reasons and for many more that I do not have the time really today to get into, criminal justice and its reform become weighty matters. And indeed, the new set of legislations that we are here to deliberate upon today during the course of this one-day national conference, namely the Bharatiya Nyaya Sanhita, the Bharatiya Nagarik Suraksha Sanhita, and the Bharatiya Sakshya Adhinaya, the new terms, the new titles by which these new laws will be known. These are not the first attempt in independent India to reform the criminal justice system, and I am sure they will not be the last. At this point, I would also like to mark some of the earlier attempts, because all these tensions have come up to the fore, whether it's the Malimat Committee reform or the Justice J.S. Verma Committee reform. So I'll begin with the efforts by retired Justice G.S. Malimat and the committee headed by him. He was former Chief Justice of the Kerala and Karnataka High Courts. It was a very interesting time for me as the law student at NLSI in Bangalore when the Malimat Committee reforms report had just come out. And it was very interesting that many of these themes that we are talking about today were sought to be addressed by the Malimat Committee. And particularly what I found quite transformative about the recommendations was the shift proposed to move from a purely adversarial system where a judge is an umpire to an inquisitorial system. There was also a great deal of attention paid to ideas around witness protection, ideas around what you do when witnesses turn hostile. So all of these matters were actually discussed at length in the Malimat Committee report. Similarly, a little later, we saw the Justice J.S. Verma Committee report again deliberate upon reforms of criminal law. There were many aspects to it. One that captured a lot of national attention at that point in time was the focus around how to define sexual offences, particularly the offence of rape, and very, very interesting debates around the age of consent. But something that struck me very interestingly is what Professor Mrinal Satish of NLSI Bangalore pointed out. He says that while a lot of national attention and media attention was harbored or garnered by this focus around the redefinition of some of these offences, there was some work silently done by the J.S. Verma committee, which in turn found presence in the 2013 amendment to our criminal laws, particularly the IPC and the CRPC, which were focused around the procedures, right? The various procedures, and particularly when it comes to sexual offences, the kind of manner in which we gather evidence and the way in which we conduct cross-examination. So there were especially of the victim. Right? So there were a lot of interesting interventions made. But I think what is unique to these new set of legislations is the political will behind ensuring the success of these new bills, or new acts, now the new acts. So I'd like to take a few minutes to just talk about the underlying themes which are quite important, which have dictated in many ways the course of these laws and the content. The first that I would like to address here is the focus around decolonialization. Decolonialization. It's a very loaded term, decolonialization. Of course, the attempt behind the laws is to move away from what we call a colonial hangover behind many of these laws that exist. Indian Penal Code of 1860, the Indian Evidence Act of 1872, the Criminal Procedure Code, no doubt, of 1973, but which again takes a lot from the procedures that were laid out in the earlier Act of 1898. Right. So it's very interesting that when we talk about decolonialization, we also talk about some of the substantive offences that have remained in the book, most notably Section 377. And at this point, I would like to note what Justice Chandrachud said in the Navte Johar case when noticing the colonial hangover. I quote, 87 years after the law, that is Section 377, was made, India gained her liberation from a colonial past. But Macaulay's legacy, the offence under Section 377 of the Penal Code, has continued to exist for nearly 68 years after we gave ourselves a liberal constitution. Gays and lesbians, transgenders and bisexuals continue to be denied a truly equal citizenship 7 decades after independence. The law has imposed upon them a morality which is an anachronism. Their entitlement should be as equal participants in a society governed by the morality of the Constitution. That is, in essence, what Section 377 denies to them. In many ways, when you undertake a project of decolonialization, the assumption is that we are aiming towards a level playing field where the state and the subject are much more in conversation rather than in a hierarchical relationship. However, we must also be mindful that criminal law is not the same as digital public infrastructure. The state's role is not that of a mere service provider of goods and services. It has a much tougher role and very important calls to make, and through the course of today we are going to hear from each of our distinguished panelists on what these calls are, be it in the matter of substantive criminal law, procedure or evidence. Therefore, I will only say that finally we have to look at how well the capacity is built within the various arms of the state, be it the judiciary, the police, the prosecution, and of course non-governmental organizations as well, many of whom have the mantle often of providing that capacity building. In that regard, I would like to mention a recent article I read in the Hindu, where it was mentioned that about 35,000 police officers in the state of Tamil Nadu have already been trained as far as these new criminal laws are concerned. The Central Detective Training Institute in Hyderabad has served the role of a nodal training hub. And of course, we'll have to now see how that training extends to the remaining, I think, 1.2 lakh, 5 lakh police officers in Tamil Nadu State Police alone, and of course all across the country as well. So training is going to be an important theme in our conversations today as well, and how capacity building occurs. I am confident, of course, that the title of these legislations, though it is hard if you ask me personally, and I think many of us in the southern part of the country especially, we may share that sentiment. It may be difficult to pronounce or record. I am pretty sure that there will be extensive work done towards translating the content of these laws in various vernacular languages, because the Honorable Supreme Court has time and again mentioned that inclusivity is going to be an important focus in the years and decades to come. Similarly, I can see that the central government too has put in a lot of initiatives already in way to translate the content of important laws, and I'm sure this will be one of the most important laws taken up for translation in various vernacular languages. So overall, I would say that this is a very interesting moment in our history as an independent country, where we are trying to bring in these new criminal laws and try something very different to move away from the colonial yoke in many ways. But then we'll have to see how these laws are implemented, and I'm sure all our panelists will have very different views and points of critique as well today, and I'm looking forward to hear that. At this point, I really would like to take a moment to mark my gratitude and appreciation for somebody who is really the person I would credit as whose brainchild this entire conference is, that is Dr. Surana. Sir, thank you so much for initiating these conversations, saying that we need a lot of focus on capacity building and putting together the resources of the firm, bringing us Vinayaka Mission's Law School as a knowledge partner. I really thank you. I extend my gratitude to you. Round of applause. Thank you. Being a young lawyer from Mr. Arvind Datta's chamber back in 2007, I'm very familiar with the law firm ecosystem, and I've seen how Surana and Surana International Attorneys have grown its strides over the past decade or 15 years. It's truly remarkable, and I think it's the vision really to build a firm which is globally competitive, which I would say for Chennai is fairly rare. I've not seen it happen very commonly, and that explains how SSIA is today in the top rankings in multiple rank lists among firms in South India, firms in India, firms in Asia, has many multinational clients, Fortune 500 companies. But I would really say, as an educator, it is not any of these distinctions that stand out. For the clients, of course, this is very valuable. As an educator, where I come from, I look at SSIA as the most committed law firm in India today when it comes to promoting legal education. I must really say this, that when I came in here, walked in the very first time with a few ideas, what Dr. Surana and the team did is to build on these ideas and say, why don't we do 10 more things? So it's truly one of those endearing places for us to come whenever we come to the city, spend some time and get all that encouragement as legal educators, and I think my faculty would also agree. As far as we are concerned, Vinayaka Mission's Law School is now in its third year. We are very committed to the idea of inclusivity, and which is also one of the reasons why this event particularly means a lot for us. Because we see India and Bharat being driven, and particularly criminal justice reform and the work being driven by the various villas and taluks across the country, and many first generation lawyers who may not even have had the felicity of an English medium education, so to say, being the drivers of security and justice to the various stakeholders in our country under these laws. So we take this as a matter of pride that we are here today as a knowledge partner, and that we are here to engage in these conversations that provide awareness and shed some light and insights on what these new laws would mean. Before I conclude, now that you've heard me patiently, I would also like to take a few moments to highlight how your day would look like, all of you assembled here. Inaugural panel is moderated by Sri Kalyan Jabba, and it will set the context for criminal justice reform, of course ably led by Honorable Justice K.M. Basha and my colleague Naveed from Vidhi Legal. I look forward to hearing both of you. And then we have 3 different panels, each of them with stellar panelists. You would have seen the agenda, and each of these panels will dedicate themselves to one particular topic. The first will be on the substantive law, the second on procedure, and the final panel from the day on evidentiary justice. So I hope to engage with all of you during the course of today as well as beyond, and to hear all your insights and really develop something around these criminal laws, these new criminal laws, which can also go by way of capacity building as well as training our students and all the various students from various institutions assembled here today. Thank you very much for your kind audience.
May I now call upon Dr. Vinod Surana, Managing Partner, Surana & Surana, to felicitate Dr. Anand Patnabhan, Dean, Vinayaka Mission Law School. So, to begin the program, we have an inaugural session to give us an overview of what our day would look like. This session will be chaired by Mr. Kalyan Jagab, Senior Partner of Surana and Surana. He is a practicing advocate, registered patent agent, and has represented innumerable clients in landmark litigations across various courts and records. He is also leading the dispute resolution practice at Surana and Surana. May I now request Mr. Kalyan Jagab to take a seat at the stage. Thank you, sir. On the panel, we have Honorable Mr. Justice A.N. Basha, former judge of Madras High Court, former chairman of Intellectual Property Appellate Board, a senior advocate at Supreme Court of India. He has an extensive practice in both civil and criminal laws and has delivered some of the important judgments shaping the civil and criminal judicial system. He is also known for his constant encouragement to the young lawyers. I now request Honorable Mr. Justice K.N. Basha to kindly take his seat at the stage. Thank you. Along with him, we have Mr. Naveen Mehmood Ahmed, Senior Resident Fellow and lead at Midi Center for Legal Policy. It's a non-profit organization that has extensive legal research on government policies and laws and contribute to bringing in new strategies to the legislations. He holds a law degree from National University of Punjab and a master's in law from Tata Institute of Social Sciences, Mumbai. I now request Mr. Naveen Mehmood Ahmed to please take a seat at the stage. Thank you, sir. Over to you, Kalyan.
Good morning to one and all present over here, ladies and gentlemen. As it was said in the opening speech by Mr. Anand, that it is a decolonization that we are looking at and a change in the perspective of how the laws are to serve the people of the country and help them move forward. So in that context is what I would like to say, that these laws are necessitated because there's been a change in social, economical, political, and technological fields. And this has brought about a lot of change in the behavioral aspects of people too. Technology has helped, it has changed a lot, and I think that has been addressed to a large extent in the current laws. And the criminal justice system, it is not just the penal laws that matter. The investigator, the prosecution, the courts, the prisons, they all need to work together and not in isolation. And in that context is where the three new laws come into play. And it will be over to the panel to give in the larger context of how these three laws are not just an old wine in a new bottle, but are seeking to bring about a lot of fundamental change and help the people move forward and away from the old mindset that we had. Over to just the question, please.
At the outset, I'm really happy to be here. I am little nervous and feeling discomfort because we used to hear the arguments and dictate judgments, products, orders by sitting. And in a matter conference like this, I used to stand on the podium and address the people. So this is a new experience. Soon after entering this hall, I asked Brother what is this? What was this? Sofas were kept on the dais. He told me we have to sit on the dais, and the other proceeding to be the comparable with that. Welcome speech also addressed very nicely, very effectively by our background. So first of all, kindly excuse me if I am wrong. I may not be. Secondly, I never thought that our brother Kalyan Jamak will be finishing his introduction so sweet and short speech. When your time the thinking process of it, but suddenly he has completed and asked you to start my address. My dear brother.
I did so in the firm belief that my Lord lives up to his name of Bhaskar, and as we know in Tamil Nadu what Bhaskar means.
My most respected and affectionate senior advocate, philanthropist, what else I can say, P.S. Surana, a great gentleman, who is the founder of this wonderful institution, Surana. My dear, young and dynamic, ever charming Dr. Vinod Surana, the finest young gentleman. Now he is known to the world, internationally recognized attorney in all the fields. He never left any single branch of law, whether civil, the criminal, constitutional, original side, that side, this side. He is very, very popular, and he has made a remarkable achievement to get the name of World International Matters Moot Court, the largest project, the world training was here. My dear, most affectionate brother, Kalyan Jamak, the senior advocate, I had a wonderful opportunity of hearing his arguments, in very number of matters, including arbitration, very soft, sweet, at the same time very effective, very persuasive, for his own way of presentation of case in the best possible way. I must tell about this audience, two of the persons sitting here, one is on the dais and the other is waiting to occupy the dais. By this time, I would have called them happily, as addressed them happily as Honorable Justice Kalyan Jamak, Honorable Justice John Satyan, my good friend, my colleague. He is from my office. I'm very proud. Unfortunately, in spite of recognition by the Honorable Senior Judges, unfortunately, that happy event is not televised. Of course, it is a blessing as it is said, they are leading in the other field profession. It's very really painful for me. Both of them are very able, efficient, competent, deserving people. They should have been, they have been invited. They not went and asked anyone. They have been called, invited. But unfortunately, that was not very nice. I don't want to say anything more. They are sitting here. I am happy to meet them today. Mr. Dr. Anand, the young and energetic gentleman. When I saw him, I thought he is also one of the students coming here participating. Then only he introduced himself that he is Dr. Anand Badmanavan. He was a dean, a very highest position of the university, in a law school, Vinayaka Mission Law School. Today I am fortunate. Today is the first time I am hearing about this law school. I asked Dr. Dean, Dr. Arun, I have never heard about this institution, but for the first time I come across this institution. I'm very happy because I know Vinayaka Mission, they are the leading education department. From the leading medical college they are having other institutions, very important institutions. I'm equally happy that they have also started this law school and also appointed a very young and dynamic, very excellent advocate, full of knowledge of law and other subjects, Dr. Anand. Then Mr. Navid Ahmed, Senior Resident Fellow and the Center for Legal Policy. I heard about the Vidhi Center for a long time. They have interviewed me when I was chairman of the Inaugural Court at Delhi. Just of certain aspects. They are doing a wonderful job. I'm very happy to meet him today. Dr. Kardosamy, IPS, retired former DGP, Director of Vigilance and Anti-Corruption, Dr. Arnold, Dr. P.R. Raja Venkatesan, all of them are participating in the morning session. Then in the afternoon session, Dr. C. Fomina, Assistant Professor Vinayaka Law School, my most affectionate sister, she has yet to come arrive in the hall. Maybe probably she may come in the afternoon because she is participating in the afternoon session. Dr. Justice Primala, Mr. Gauri Shankar, Assistant Professor, Satyabama University, Mr. Ramya Subramaniam, Advocate, Madras High Court. And again, Mr. Vishal Shekham, Associate Dean and Associate Professor Vinayaka Mission. Mr. Nitish Kadral, again a young and energetic Commission Advocate. Mr. T. Gaudaman, a very leading Senior Advocate. Dr. Hemalada, and I most affectionate younger members of the legal fraternity, other stalwarts sitting here. The parliamentary is sitting in front of us. They are very fortunate today. Mr. Sandarajan, very able, efficient, very popular parliamentarian. His presence is really gives strength and energy for people like me to participate in this wonderful event. And the students of law, and my most affectionate members of the legal fraternity. Some of the advocates are also present here, sparing their precious time. I'm very happy to see you all. First of all, I deem it a great privilege, pleasure, and pride to stand before you, before this august audience, consisting of several stalwarts. Just now arrived my good friend from Delhi, leading the Supreme Court advocate, younger dynamic Mr. Nagarik. He is the advocate on record, and he is doing excellent work there. As a matter of fact, he is attending my work and the work of other seniors he was earlier attached to. He was still attached to, and just now passed from here. Earlier, he has started his career from Chennai, from the North High Court and other high courts. The director shifted to Delhi. And within a short span of period of 10 years, now he has completed for more than 20 years. He has made his remarkable achievement in his profession, and he has every day he is appearing not less than 10 cases. He is appearing every court. I'm happy that he is here. He has come to a vacation to visit the David place. Fortunately, he is sitting here in front of us. I'm very happy to see you all. Now, coming to the subject, really, it is very important subject. 3 laws. Before the time of while I was sitting, a young student of law, Ms. Bharatiya Nagarik, BA LLB honors student from Chennai School of Law. She has given a write-up, an article about these 3 statutes, 3 laws. Just I went to just through very excellent work she has performed. She's having very good future career. Not only on the academic side. I wish that she could come to the litigation side because the appreciation, the consideration, the condition, everything she has done very, what I can say, very softly, swiftly, everything put it in a neat way. She has stated now the law has been going to be introduced, going to come into force. 1st July is not far away. We are almost nearing. But still, fortunately, unfortunately, these three legislations, three acts are not received the wholehearted acceptance by all sections of it. We are not sitting here to criticize the act. We are not sitting here to criticize the other aspects. But now it is time for us to concentrate on what all the provisions are available, what all the changes made, how it is helpful to the public, helpful to the citizens of the country, helpful to the litigants, and helpful to the rights of the people, both the victims, affected people, and both the accused. As far as the accused is concerned, my humble view is always the cardinal principle of criminal law is accused is innocent till the guilt is proved. I don't think that there will be a different opinion from others. In a criminal case, it has to be proved beyond reasonable doubt. There is no doubt about it. But in the new legislation, certain beneficial provisions have been made to protect the interest of not only the accused, but also to the victim. There are provisions, like my friend John Satyan is addressing many number of last few months he is going on addressing in spite of his busy schedule of his practice as a senior advocate, appearing many number of sensational matters recently. But in spite of it, he is also allotting his time slot for occasion like this to discuss with you, to share his views with you. So this is very, very important. Several provisions we have to look into it and concentrate. In this, all these three bills have been the President on His Excellency Honorable Draupadi Murmu on December 25th gave an assent to the three new criminal code bills which were cleared by Parliament 2023. In 2023, it is decided that all these three acts will come into effect from July 2024, according to a notification by the Ministry of Home Affairs. As far as IPC, Indian Penal Code has been replaced by as Bharatiya Nyaya Sanhita 2023. And this act will have 356 sections instead of the earlier 511 sections. 175 sections have been changed. A 8 new sections have been added and 22 sections have been repeated. As far as the Criminal Procedure Code is concerned, 1973 has been replaced as Bharatiya Nagarik Suraksha Sanhita 2023 and now has 533 sections. 160 sections of board law have been changed. 9 new sections have been added and 9 sections have been retained. Then coming to the Indian Evidence Act 1872 has been replaced as the Bharatiya Sakshya Adhinaya. I am also studying from acts. And will now have 170 sections instead of the earlier 167. 23 sections have been changed. 1 new section has been added and 5 have been retained. First of all, my view is, and you don't mistake me, here we are sitting here to express our view. I may be right, I may be wrong, that is entirely different. There is no need for changing the title of the act. We are accustomed to all these 3 acts, not now, several decades. If I remember correct, more than 7 decades or 8 decades. From the time immemorial, I know IPC, I know only Cooper Procedural Code, I know only Indian Evidence Act. See, in IPC, even a layman will say what is the provision. For instance, you take the case of 420 cheating. 420 is for cheating. People used to call, he is 420 number 1. So, Such a reach it has reached the pupil, the masses, the litigant public. Now they have to go understand, they have to follow, they have to remember, they have to memorize. All these things are there not only to the public but to the students of law, the legal fraternity members, advocates, judges. How many years we are going on? I must be very proud to state after this school of excellence and after the national law schools, several aspects. The youngsters are coming really, I cannot say that talent, the capacity, the caliber has increased. We are getting law interns. I do during my judgeship, I had a law clerk. If I say a point, Mr. So you kindly look at it, there is a decision on this aspect. I remember correctly 1980 Supreme Court regarding right declaration. It was periods is able to take. Such a capacity, they know how to apply their mind. They are doing their studies itself, they are having by heart the provisions. If I say subject, they will immediately go to the provision, pinpoint what is what, then they will go to the subject, what is the decision, right declaration, what is the date decision, they will come up with the immediately. And this is the data. So after all this exercise, now they have to enter into a new field. One thing is, one plus point is about this 3 Act. Major portion is said. What is said? Overhaul and state. The contents of the large number of provisions are what are the same. No change at all. But only change is the title given to the acts. The provisions are numbers changing. Except that there is no major change. But I am at the same time happy to state certain new provisions have been introduced. The object is very excellent object. The award object of these 3 new legislations with bold provisions, changing here and there, modifying here and there, and removing, adding all these exercises is entirely different. That there may be some reservations for us. But the award object is to reach the public access to the justice. Number 1. That's first and foremost. Okay. Protection to the victim. Victim protection, there is a separate provision. If time permits, I will have to highlight those important provisions here and there. Then protection to the accused and protection of false implication, false and frivolous cases. How many cases we have come across? False corruption case, false rape case, false murder case. In very serious offences, they have been implicated. What for? The personal identity, animosity, this and that. Ultimately, the real culprit will escape. The innocent people will be implicated. That is why again and again we are concentrating the cardinal principle till the truth is proved. The prosecution is bound to prove its case beyond reasonable doubt. There is no concession, nothing. As far as the defense is concerned, they can prove their case by preponderance of probabilities. Of course, there are certain stringent provisions of their presumption in a corruption case. If the money is recovered, it has to be presumed it has been received for illegal gratification. But even for presumption also, the basic foundation to be established by the prosecutor. Then only they have to turn into the presumption against the accused. The corruption case, now the latest simplification of law is here recovery is not sufficient. You have to prove in a corruption case demand of illegal gratification. That is the first and foremost ingredient. Unless or until you prove the demand of illegal gratification from a person, mere recovery from his table, mere recovery from the betrayer, mere recovery here and there is itself consumption. In my experience, I have come across many number of cases, thrusting, planting, this kind of thing we have seen. In one case, in my experience, I have conducted as an advocate, not as judge. In one case, you have the top officer of the corporation, not the Chennai corporation, it's a big oil company, I don't want to mention. So top officer, his duty is to allot the contractors for lorry, the transporting the oil. There, the contract is to be given for a particular person by following the certain procedures, certain terms and conditions. The gentleman has not followed. The officer is very strict. So he said nothing can do. Unless and until you follow the procedure, you satisfy the terms and conditions, I cannot afford I cannot give a contract for people like you. He had a vengeance in collusion with another very same officer of the corporation. That fellow wants to become a investigation. So what I did, first and foremost, the thing is to verify this officer. I was going on inquiry. What happened? How that happened? Why? What is that? How long you will have there in the corporation? What is your background? Every day his wife from Kochi used to call me and try in the morning 7 o'clock. Save my husband. So back to the case, this gentleman satisfied me that he is after 1% he does. I have to ask each and everything, the particulars, the way in which overall the entries. Then one witness gave is the sanction witness, John Satyan and the Atmosphere. The collection gave for officer the sanction to be accorded by the IS authority. He gave. Normally, we use put simple questions without application of your client is simply your what are the purpose producing your product. According to the materials, kind of this and that. I started my cross-examination. First of all, inquiring about the background of the application. How long he is working? Is there any doubt about his identity? What are his nature of his work? How he has worked? What is his? All these things I have asked about several questions and got several points. In the sanction witness, itself I got points. The money was kept in a file. And the traffic party went to the place of his house. Nobody will ask. If he has asked to come and give the money at the house by 6 o'clock, the officer will be waiting for that. Here they went to thrice paid, track paid, not person. He is staying alone. He is taking food outside after office work. He completes all his office work and reaches home late. On the way, he used to take some dinner, some hotel. He comes, these people are standing. What for your come? Sir, I brought all these, what are the requirements of the box, the documents, all that. That was to bring it to the office. Most of we thought we want to save the time. We want to show it and correct it. All the documents are correct. All that comes in. He went inside about the restroom and came back. Before that, he has kept it in the file amount. Then outside the spared he went to open the immediately saw that it is a point out. At the time he has touched the notes, currency notes, we had to pronounce them covered. After one of the person went and gave the police party came, conducted the raid, amount is. This is only my difference. Their case is, they went inside, he was asked, demanded, then he said, yes, I brought the money, then he gave the money. All these things, their possibilities were, I was able to come out, bring out all the materials what we have difference established. Ultimately, I got wonderful points. And not only that, through the person who gave the complaint, from him I asked, how do you know this corruption vigilance are handing out the office? Who has won the office? Who has drafted the complaint? Then as soon as come out to the same officer who is working in the same complaint. So we are able to establish motive for implication. We are able to establish it is a pattern one. This officer is innocent. And nearly that case went on, we had 2-3 judicial officers. Ultimately, you have been concluded. The another plus point is after seeing the position, it's a CBI case. They have rightly decided not to prefer any of this. That is how it happens. So these are all the things are there.
So, my lord, just taking a cue from what my lord said about the incident which happened, how will the current laws which have been brought into which will come into in July and the electronic evidence which comes into play, how would that be able to help avoid such a situation? Your views or your views, everyone's views. Would the electronic evidence which is now proposed in the new laws, will they be of any help in getting them over?
Certainly. Let me say, before that, I will say only one answer to him. Let him explain. Electronic evidence, even earlier we have tape recorded evidence is admissible, electronic evidence is admissible. In one corruption case where my senior appeared and conducted, it was videographed. Event one step advanced. Central excise officials have been implicated in the corruption case. Complete video was taken. So it is really available, but certain conditions about the authenticity section 65D certificate is that you will take. Yes.
Firstly, thanks very much for inviting me here and allowing us to speak to such a wonderful gathering. Thanks. I first broadly discuss in terms of why and what my initial thoughts were when these laws were given in the Parliament last year. Two immediate thoughts came into my mind, and one of them was that this is perhaps unprecedented, where the whole criminal justice system, the edifice of the criminal justice system, the substantive, procedural, and evidentiary laws are being looked at afresh. We have over the past many years, many decades, reformed and attempted to reform these laws. We've done it through a piecemeal manner. We've done it through various levels, through amendments here and there, through enactment of special legislations. The system as a whole has evolved through various judgments of the Supreme Court and the High Court. This is perhaps the first time where we've taken the opportunity of looking at the very basic first principles of India's substantive criminal law and procedural laws. And it was a great opportunity to truly lay a fresh ground for India's, for a 21st century modern criminal justice system, when we were able to reimagine what should be a crime in India, what is an appropriate form of punishment in India, can we look beyond imprisonments, can we look at community service as a form of punishment, what are the other forms of punishments that we can explore. Because it's a system that we've carried on for about 150 years. The society has changed, the nature of the society has changed. We are an independent state. Our outlook towards the citizens has changed, and it's remarkably different from what it was 150 years ago when Macaulay was thinking about ways in which the Indian population could be regulated, could be controlled. And criminal law, criminal justice system was not just a means to ensure public order. It was a means to also ensure how the economic and the political agendas of the colonial administration were to be implemented. So it became a critical instrument at the hands of the government at that time. So, as I said, the first thought that came into my mind was this is unprecedented, where we're able to look at things afresh. The other thought was that there was an acknowledgement coming from the highest decision-making body in the country, the Parliament of India, that our criminal justice system is still colonial, it lacks citizen-centric processes, and its focus is on punishment over justice. Again, an unprecedented situation to my mind, where the Parliament acknowledges that a system that regulates each one of us present here, that has a deep impact on all of us in our interactions with the police, in our interactions with the courts, in the way we behave in our society, in the way we interact with each other. The impact that the system has on the lakhs of people that it processes on a daily basis, the lakhs of under trials in jail every year, the huge amount of pendency of cases in the court. So there was a great acknowledgement of these issues, which I believe is very significant. Whether these laws are able to achieve that or not, as Mr. Pasha said, is it only the names that have changed? The substantive character of these laws, do they remain the same or not, is something that we will, of course, discuss through the course of the day today. But now coming to your question on electronic evidence and how things like this, there are improvements in the law that have been acknowledged. especially the Code of Criminal Procedure now replaced by the Bharatiya Nagarik Suraksha Sanhita. These are elements, technological advancements that have come in over the past many years. Whether it is through video conferences, whether it is video recording of evidence, searches and seizures, whether it is filing of e-FIRs, whether summons be issued over WhatsApp and emails. These are technological additions that we've over the past many years accepted. Maybe the past 2 years of COVID really pushed them, and we do have legal recognition to them through these new laws. But the question really remains whether they really change the character of the criminal justice system, or are these mere technological adoptions that were anyways being taken up. So that will, of course, we have to see once these laws come into force, starting maybe next week, in another 10 days. We will really see how these play out. Do we have the capacity? Do we have the resources to ensure forensics, involvement of forensic agencies across for all offences punishable with over 7 years? Do we have the resources to do that? Of course, I think this week only the central government has allocated some 2,000 crores for that. But do we have the resources to ensure that all of these searches and seizures are video recorded? Do we have the mechanism in place to ensure the police officers have body-worn cameras, and how are we going to do that? These are things that we will all see gradually playing out in the next 3-4 months, and perhaps then we'll be in a better position to see how these laws shape our criminal justice.
Taking off from what you said, one of the other changes which we have seen is whether the witnesses are there or not there, because often the accused not being present, not traceable, the entire thing gets stalled. Now, the changes in that system, would it help speed up the trial and the disposal of the cases as such, your views? The law says that even if the witnesses are not traceable or the accused is not present, the trial can still go on, which earlier used to get entire thing used to come to a standstill almost, because still they are traced back the entire thing unless the case is split up. With the new law which is saying that the trial can still go on, would that, in my lord's opinion, help speed up the trial and move matters further? What is my view, lord's view?
As far as the accused is concerned, even earlier, as per the existing laws, if an accused is absconding among the 7 or 8 accused, this case can split up and proceed. Now the latest development, one plus point I feel that will be helpful for speedy justice is the provision in absence of the accused, trial can proceed. So that's a plus point. Definitely that will be helpful for speedy trial, speedy disposal of the case. As far as the witnesses are concerned, most of the cases they are present. That's what you feel here. In some cases, due to change of address, this and that. Now the procedure followed is issuing NBW, issuing summons, this and that. Lot of other provisions are there. So therefore, that will not cause any hindrance for the speedy disposal of the client. Client will proceed. Another aspect is I would like to stress important aspect. Unnecessarily the police investigate cite many number of witnesses. For one aspect, they will give the list nearly about 10 witnesses. That is unnecessary. If 2 witnesses count this time, if one witness is a very reliable witness, effective witness, that is enough. For that, they will go on adjourn. They will ask the prosecution will ask adjourn. They are anxiety. Even if there is a case, there are weaknesses in prosecution, definitely they will take care about time. We have to bring this to that, we have to bring that. He is not available, we are searching this and that to that. As far as the existing procedure is concerned, simple. Only thing is, we have to see that the adjournments could be contained and restricted. Except for the genuine reasons, there is no question of that. Already politically is there. Certain number of appointments have been made earlier. Adjournment also very strict. Day out to the judges are insisting. And as far as criminal trial is concerned, for many offences, it has to go ahead day to day. For instance, in a murder case, it has to be conducted day to day basis. No question of gap stopping error there. But The witnesses citation, the unnecessary witnesses, the prosecution has discussed with. Concentrate on the material witnesses. For instance, for recovery, they will examine the 3-4 witnesses, manager witness, this witness, that witness. Then at the time of recording the confession, all these things could have been avoided for the speed of the process of the examination of witnesses and conclusion of the trial.
There is a provision, I think, that's very limited in its operation about trials in absentia for project offenders in some of the cases. Is certainly welcome considering if there are cases pending in that regard, but of course keeping in mind that there may be concerns with regard to principles of natural justice and whether there is adequate representation and all of those things considered. But my question here would be, did we really consider the fact that are these the cases that are clogging up the system? Are we solving a problem that is not necessarily there? Because if you look at data, the number of cases, the 3.454 crore cases that are pending in courts right now, I think it would have been beneficial to look at the nature of these cases, the stages at which they are pending, and then perhaps look at what is the best way to solve these pendencies. If I remember correctly, around 60% of the cases are pending because we are not able to secure presence of the accused. So a lot of these cases, whether there are amendments made in the procedural law, whether there are amendments that have been made in CRPC, are able to address our provisions, are able to address our concerns about bringing this accused person to court because their presence is not being able to secure. So that could have really had an impact considering issues of pendency.
My brother is talking about the speedy disposal, speedy justice. Another important aspect is speedy delivery of judgment should be there. Now there is one provision included. I'm really happy. Months together for your information, years together we have come across cases. Judgment reserved, no problem. Recently we have come across the Kerala case you would have seen in the paper. A judge pronounced just appeal allowed or dismissed. That's all. Content of judgment not delivered. Not only in the subordinate judiciary, but in subordinate judiciary, I have come across in one matter, one judge reserving nearly about 400 to 500 cases. Something unimaginable. By the time the transfer has come, he wants to what to do the cases. The complaint came and inquiry conducted, and where the judges sat for inquiry, they found the for the reasons best known. This man, I don't want to go one step further to say what is happening in the higher side. It is really painful. It's a great agony. We are simply blaming the police or the defense for the delay. What about the delay caused by the justice delivery system? In one case, in the High Court itself, I very unfortunately have told appeal allowed the went up to the Supreme Court. So this provision led us to provision in the Criminal Procedure Code, namely Bharatiya Nagarik Suraksha Sanhita 2023. The very excellent provision is fixing mandatory requirement of 30 days for pronouncement of judgment. Of course, we have our Supreme Court decisions. If there is a delay, 2 months they have to dispose of appeal other things after the arguments. Even 2 months itself on the higher side, I think. See, then and there, if they hear the argument, they have to deliver. Dictate, start dictating, that's the best method. Otherwise, they used to forget. Some judges noting down, some judges not noting down, some judges are taking notes, some judges not doing it. Some judges ultimately the judgment comes in a different way. What the counsel argued is not there. And that is not considered. The complaint comes, the grievance comes. Net result of the casualty is justice, nothing else. So certain new provisions are really encouraging. In all aspects, see, medical examination of report on the victim of sexual harassment will be forwarded by the medical examiner to the investigating officer within 7 days. Over stage there is a delay. Where else we have to go? Yeah, but there are several good provisions are there. The bill outlines new concepts like the timelines for messy petitions, a scheme for witness protection, and permitting electronic modes for recording statements and correcting evidence. These are all the plus points. So here we have both the plus points and minus points. If, in respect of minor points, we have to it has to be considered by the concerned government or authorities concerned to modify or amend the provisions suitably to clear all those electrons. Procedural requirements. Police must be present their demand before the court within 7 days of the first hearing. Then even at the initial stage, the victim has been driven from pillar to post. When they go for giving a report immediately, they go to the nearest police station. That police station will say, your offense committed in different jurisdictions. I cannot able to go there. Then he goes there, going on. Now, the excellent provision is, a victim or the person affected can give a report to any police station. Right, sir? Then thereafter, the concerned police station to dispatch to the jurisdiction police. Some people, the big shots, they used to go and give a complaint to the DGP commissioner. That takes a long time. The highest authority receives and puts it to the Tamal section. Tamal section will keep it for some time. They go to Surana. Then they send it to the place of the concern to the jurisdiction police. By that time, the accused will escape and stop. Where is he? See, everywhere there is a delay. That is the reason for that is why the speedy disposal is affected. Speedy justice is a fundamental right guaranteed under the Constitution. Where else we are going? All the wings should work as per their concepts. The police, the defense, both, everyone should work. Concentrating the justice to be delivered at the earliest. Justice delayed is definitely justice denied. That is true.
In keeping with what my lord said, since you have been part of the committee earlier, can you give some thought process which went into what is being addressed to ensure that all the stakeholders are able to stick to the timeline, starting right from the investigating person, from the prosecutor, to the police, to the defense lawyers, to the courts, to the jails. Have they done anything about the infrastructure? Has anything about that also been taken care of or been said about that? Your views on that? How will this impact the infrastructure and the justice delivery system in view of all the drawbacks which my lord had got, practical drawbacks which we currently face? How is that going to be addressed?
I'm referring to the criminal law reforms committee. Yeah, we weren't part of the criminal law reforms committee that was set up back in 2020 during COVID. But that remains, we are not very aware in the sense that what consultations were carried out in those 2.5 years of
My question
Yeah,
is,
fine.
how would this impact the existing infrastructure and how do you think they'll be able to cope up with it? I'm just giving a small, more like an impact study whether it has been done or not with the new laws and timelines coming in place. Like the 138 cases which came in, I think there was no impact study done saying how it clogged our entire magistrate court system. So something like that, has anything been done?
That's what I was getting. Something of that sort should have also preceded reading about these laws. As I said, you should solve problems that really exist, and you should identify where the system is clogged, and that's precisely where you'll be able to identify the best possible intervention. I really don't believe that these three laws will change anything in the system materially. Especially considering the goals of the laws. We can talk about decolonization, we can talk about prioritizing justice, we can talk about making citizen-centric procedures. I have my doubts, I have my reservations whether these laws will really have an impact, particularly with regard to how our policing system works and how our prison apparatus works. Because any change that takes place, any mindset change, which these laws really do reflect We want to create a system that suits modern India. We want to create a system that suits the idea of justice. But that has to reflect in our practices in prisons. That has to reflect in our practices in policing. But there are no material changes that have been made in that regard. And whether any impact assessment has been conducted, nothing as of yet. Whether an impact assessment was conducted before these laws were brought into place, I am not aware. Because there's one example that I can give, and I think I did refer to that earlier, with regards to the forensics. We do not have the capacity to ensure that all crimes over 7 years of imprisonment can have involvement of forensics. You can of course push it, you can of course increase it, but it will take time. But you can't mandate, you can't create a mandatory requirement under law before having such changes in the provision itself. The other issue is our ideas of the idea that these laws are trying to thrust is justice, and one of the changes that the law brings in is community service. But we don't really have a mechanism, an apparatus in place to ensure what kind of community service are we going to give. In fact, the first version of the bill that was tabled back in August 2023 did not even define what community service would be. They had, in the revised version in December, community service was then defined, which now broadly is in sync with how it was set under the Juvenile Justice Act. So there are improvements that the law visualizes. There are improvements in the way of justice that the law visualizes. But we really need to think of how do we really translate it into our functioning on a day-to-day basis.
That aspect, see, in certain cases, first of all, the court has to take a decision, and the prosecution has to take a decision whether the evidence of forensic science expert is required at all. Just before the commencement of this conference, I had the good fortune to discuss with the madam sitting here, a forensic expert professor. In one matter, where my senior, my mentor, my guiding star, Mr. M.P. Vanma, popularly known as MTV, I engaged him for conducting a trial in a murder case, husband and wife case. Both of them were living happily. One fine day, they found they went to the even in-laws place for a festival occasion, stayed there for 2 days. Just both the rooms are opposite. One room, the husband and wife with the child. Opposite room, father-in-law and mother-in-law, they are sleeping. In the midnight, they heard a crying of a child. So the mother-in-law went there and knocked the door. This fellow was having a sound asleep. Then he opened the door. He found the child is crying. Husband is lying. He was told he was sleeping. The daughter is missing, wife. Then they found in the bathroom. The case of the prosecution is he has called kerosene and set fire. The case of the defense is no, nothing happened. She has committed suicide. Self-immolation, that is the case. The case is very on the face of it. First of all, there is no suspicion, not even a suspicion expressed immediately after that. Everything went on smoothly. They buried the body, conducted the prayers, husband participated, his family participated, everybody participated. No, you are derived from any quarters. After a period of 2 weeks, certain doubts arose against the husband. They found the husband was taking breakfast a little, he took one masala dosa and puri and idli. The brother-in-law accompanied with him to the hotel. He has taken only one dosa. That is first doubt. How can he take such a lavish breakfast? Seventh day, we are doing prayer. Second day, he is in a mood humming some Hindi song. These two reasons gave the suspicion to the father-in-law and others mother-in-law. Then immediately after 2 weeks, they are going to complain. After the complaint, the body was exhumed, taken, and thereafter conducted postmortem. Admittedly, even as per the prosecution version, body was in a very bad decomposed position. Nothing can be detected or anything to do that. He somehow or other, the expert, forensic expert, has given an opinion that death is due to anorexia and asphyxia. My senior NT, one of my colleagues, the great popular known as NTV, asked me to take this book to that book. Nearly take it from me, my dear friends. 12 medical books taken. He has asked me to take police, medical script. He has asked me to take the Cox. He has asked me to take the Taylor. He has asked me to take Jayachandra Reddy. I asked, what's up this? Then, only I came to my found, oh, senior is correct. He put all the books to the forensic expert. Asking, madam, how you have come to the conclusion? These are all the symptoms required for coming to the conclusion that this is due to anorexia and asphyxia. Did you find any symptoms? No. Then how do you say this is on my observation? What observation? But anyway, right or wrongly, I could have accepted the evidence. Only one circumstance is both of them were sleeping inside. They were together, therefore only husband is aware about the fate of the wife. What circumstances of medical evidence can be checked? High Court. It came to Appellate Court, High Court. High Court also confirmed the condition of the High Court. And it was observed that in spite of mid-shattering cross-examination, the defense is not able to shatter the medical evidence. We have taken the matter to Supreme Court. Meantime, when the fellow was languishing in the prison, usually he got bail and then thereafter confirmation of appeal arrested once again. And he had a lovely brothers of 6 brothers, 5 brothers. So my mother was very anxious to getting married once again. What is this? See, we have a good case. 90% excellent case, it has to be acquitted. But we cannot give any assurance or guarantee that it's not our action. If God is willing, He will be acquitted. If anybody is willing to give the birthright photo of Surana, tell you he is. I am not here to. It is to be it is a case of acquittal. Allah appreciated the then ultimately, he got married to the parents of appeal. And I also went and instructed you are married, person that is father was a great senior counsel. I have explained everything, prepared notes, everything I given. I told him, sir, I cannot be in a position to come again. My friend already suffered very expensive. Third, 3 stages, trial, appellate court, then lost it to court. So the ATM suffered very great advocate is there, you will be refused up to one. Ultimately, Justice Santosh said, I couldn't the right. It's an important case. The ground is medical evidence. Main ground is there is no medical evidence to prove it's a case of murder. The second ground he has mentioned is the circumstantial evidence of husband and wife inside the room. He said, yes, it is quite natural for the husband and wife to be inside the room. That circumstance itself is not sufficient. See, in that case, that is why a provision has come now. Evidence of public servants, no public servant, scientific expert, or medical officer shall be called to appear before the court unless they report such a public servant, scientific expert, or medical officer is disputed by any of the parties of crime or other proceedings. If everything from the medical from the report, we cannot say it's a case of murder. That is very clear. Still, if we want to examine further, we have to call. Cross-examination went whole day exercise. See, time and energy wasted. Of course, he is very good expert like madam. They will simply say, point is there, point is not there. Another revision. So you have to tell the truth from the materials, from the observation of the body. I may not be in a position to say anything. Sorry. You did not say it is a murder or it is not a murder. You can simply say, I cannot be in a position to give opinion because he composed the body. What else I have to state? Nothing. You cannot come to jump to the conclusion this could have been done. Presumption not required. The evidence you have to state. Expert opinion is that that's all. These are whatever you say, you have to say with some reasons. Expert opinion should be followed by reasons. There is no reason. Simply I observe, yes. Whether all these 12 symptoms are available or not, my senior asked the question. Still is ringing in my ear. Such a wonderful person. Here, I know that. We are cross-examination, we are conducting the trial. Passionately, effectively, efficiently. What a great senior. But failed. I was very much upset. Second attempt failed. Third attempt failed. I put it, attempt last year, the Supreme Court we succeeded. That's a important case. So, this is what provision is a good provision. Why is section 336? And that is the new criminal procedure code. Many number of matters, even if I remember correct, our Honorable Justice N. Vinayaka has observed in one matter, the document himself will speak, the postmortem can be done. These are the things.
Just to conclude now, I think from what both of these speakers said, it is a mindset change that we need to bring about, both in the way that all the stakeholders deal with the criminal laws, how the infrastructure comes in, and how we ramp up and accept the new laws and make sure we take it forward to ensure people benefit out of it. There may be shortcomings, but like how the IBC did have quite a few shortcomings, we've seen a lot of changes and things that we've seen and things that work. We hope the new laws bring about a lot of welcome change and the infrastructure gears up to itself to live up to the requirements of the law. Thank you so much.
I must express my gratitude to the organizers, particularly Surana, and as well as the Vinayaka Mission Law School, and Mr. Nikhil Raghavan is the gentleman who is behind the show of this conference, doing a lot of work. He only came to me, explained me about the conference and about the program, everything. I'm grateful to every one of you for patiently hearing me. It was a never-ending process. If I say go into the 3 acts, it will take 1 day minimum. So anyway, but fortunately, our friend Mr. Kalyan Jabak has touched the important aspect, speedy justice, forensic medical evidence, and victim protection is there. Then, in the respect of the FIR, false FIR, to prevent that, preliminary inquiry already held by the Honorable Apex Court and by the Constitution Bench, the Ranjit Pani case, it is there. Preliminary inquiry is necessary to find out whether the real person is given or not, whether the concerned person accused is innocent or not, they can find out in the preliminary inquiry. If they found the material on the preliminary inquiry and come to the commission, they can proceed further in registering and proceeding further. Thank you.
Thank you, sir. Thank you for sharing your views on the overall scheme of this law and some of the notable aspects. Thank you very much. May I now request Mr. Kalyan Jabak to felicitate Honorable Mr. Justice K.N. Basha. Thank you, sir. I now request Mr. Kalyan Jabak to kindly felicitate Mr. Naveen Mahmood Arad. Thank you, sir. I request you all to kindly turn off your mobiles or at least keep them on silent mode. Thank you. I now request Mr. Sanjay Sharma, Head Client Relations Surana and Surana, to felicitate some of our chief guests. Mr. Guna Singh Chedadare, President, Tirunelveli District Chamber of Commerce. May I request you, sir, to please come here. Thank you for joining us today, sir. May now request Mr. Vijay Choudhary, President, Hindustan Chamber of Commerce, to join us here. Thank you for joining us, sir. I now request Mr. Choda Nachir Rajashekar, President, Tamil Chamber of Commerce, to join. Thank you, sir. We're also happy to have with us all the head of departments from Bain School of Law, the HODs from NGR University, Mrs. Rajeshwari and Ms. Sneha, both from Chettinad School of Law, Dr. Sundari Suresh from Institute of Directors, Ms. Dilshad Sheikh, Dean, Satyabama School of Law, Group Captain Dr. Venkatraman from MMA. Thank you all for joining us today.
We also have with us the Consul General of Malaysia. Thank you for being with us, sir.
Let's take a short break before we move on to the next session. I request all the guests to kindly have your refreshments arranged outside the auditorium and kindly be back to this session for the next session by 12:15. Thank you.
Next will be your session. 2 o'clock, okay.
Although they call ourselves the industry body, there are so many training programs, so many courses. I'm not carrying.
Just give me one minute. Kanan, இது யாராவது காஃபி டைம்ல கொடுக்குறீங்க?
Ladies and gentlemen, I request you to come back to your seats, please. We will be starting the next session soon. Ladies and gentlemen, may I have your attention, please? Kindly return to your seats with your cup of coffee. Relax and drink them. We will start the next session in a couple of minutes. Thank you so much. Ladies and gentlemen, may I request you to kindly come back to your seats. We are about to start the next session. Thank you.
He's full of something of us. Can I have a card? Yes, sure. Please do sit down.
We now go to start the next session. May I request the guests to kindly take your seats. The first session for the day will be on crime and punishment. This session will be moderated by Mr. Naveed Mahmood Ahmed, Senior Resident Fellow and Lead at Vidi Center for Legal Policy. We now request Mr. Naveen Mahmood Ahmed to take a seat at the stage. Thank you, sir. On the panel, we have Dr. P. Kandasamy, retired IPS officer, former DGP. He brings over 3 decades of senior leadership in public policy. With a PhD in data science and public policy from IIT Madras and masters in public policy from UC Berkeley, he has driven systemic law enforcement solutions nationally and internationally. May I request Dr. P. Kandasamy, retired IPS officer, to kindly take the seat at the stage. Joining him, we have Mr. R. John Sathil, designated senior counsel, a renowned expert in criminal law, who's been a part of cases that have made significant judgments from tribal court to Supreme Court of India. He recently delivered an insightful lecture summarizing all the 3 criminal laws in 1 hour, and we are really looking forward to hearing from you, sir. Joining him, we have Dr. PRL Raj Venkateshan, Senior Associate Professor at School of Law, Vellore Institute of Technology. He holds a PhD from the University of Madras and began his career at Tamil Nadu Dr. Ambedkar Law University. Since then, he's worked in various institutions and holds a great knowledge in several fields of law. Over to the moderator.
Thanks very much. It's a good change in roles now. Thanks all of you for joining. And what we can do here now is perhaps we can have all the speakers here give their opening remarks for a few 2-3 minutes. And then we can perhaps go into the discussion and if there are any audience questions, if the format permits. Right. Yeah. All right. So, confirm if you can start everything.
Thank you, Dr. Mahmood. I'm really honored to share the stage with the illustrious colleagues, Professor Satyen and Dr. Raj Venkateshan. He asked me to speak a couple of minutes on my opinion. Since now I'm teaching at the management school, I'll just draw a parallel. You know about incremental innovation and disruptive innovation. Disruptive innovation, you know, like your Uber, Airbnb, your Netflix, self-driven car, and so on and so forth. Similarly, the Bharatiya Nyaya Sanhita is not incremental, it is not disruptive, I would say somewhere in between. Because has it been incremental, there have been amendments, but it's not so. There have been substantial changes. Certain decisions of the Honorable Supreme Court have been codified in mob lynching, gang rape, certain provisions of law which had very esoteric implementation from states like Maharashtra or Gujarat or Delhi, like organized crime, Mokaka or your Gujarat Control of Organized Crime Acts. The parliamentarians thought we should have one uniform act across the country from Kashmir to Kanyakumari, and therefore they brought in 2 important changes or inserted. One is the organized crime. The organized crime, don't think big. It could be as small as a chain snatching or a mobile phone theft versus organized, petty organizing crime. It could be a very big mafia of organized crime and narcotics. So they brought in these provisions. Similarly, terrorist act. If you ask any local police, if anything concerning terrorism comes, the CBCID and the NIA The judicial answer they will give. So they thought, the parliamentarians thought that we should bring in the regular terrorist act also within the ambit of the local police. Certain safeguards are there. SSO can't reach the case without the permission of the officer of the rank of SP and above. So these important changes are being brought. One most important change, while predominantly most of the offences, the punishments have been enhanced. For example, 33 offences have been enhanced, and minimum mandatory sentence has been there in 23 offences. So in this context, they also brought in community service. I think 5 or 6 sections very clearly talks about community service. One is with regard to a petty offense, petty theft less than 5,000. You are a first offender, you will get, and returning the property to the victim, you get community service. So sections like your abetment to commit suicide. Somebody is going to stage some drama in front of Secretariat, High Court saying that I'm going to kill myself, you don't give me patta and things like that. You are convicted of that crime, you get community service. So on and so forth. So community service is implemented. But overall, if you see how it is the fulcrum or the balance changes, I would say more in favor of prosecution, where it's more imposing more harder, stricter punishment for the law violators. Same time, they have also brought in some kind of solace in making a reformative step towards community punishment. Over to Dr. Mahmood.
Thanks very much. That puts things in perspective. That is certainly not disruptive, but it may not necessarily be incremental in the way that we have already been imagining things to be through amendments. Mr. Satyam, for your opening remarks.
Thank you, Nadu. I'm really honored to be amongst your best guests and a top cop here and an academician here. It's quite a diverse diaspora here on the dais. Now, this enactment, so I restrict myself to the law that replaces the Indian Penal Code, which is the Bharatiya Nyaya Sanhita, wherein the very philosophy of penal laws is now being replaced by law to render justice. That's one thing. If you ask me, as a personal opinion of mine, whether is it essential for us to have a law being replaced, a century-old law being replaced, my answer would be an absolute no, because the earlier speakers were talking about the decolonization of the criminal laws. See, we have not gone away from what Macaulay thought. Because whatever Macaulay thought was law at that point in time still holds good today. Because the legislatures, the parliamentarians thought it fit not to change the language of the provisions of law. They only jumbled, they abridged the entire IPC by combining both the definition clause and the penal clause, thereby abridging it, making it a much more smaller one. As Dr. Kansani said, yes, there are certain provisions which I've been representing myself in every other event, that these certain laws are very much essentials, like the provisions governing organized crime, organized petty crime, terrorist act, mob lynching, and all these things require a serious insight. I mean, there needs to be some kind of a uniform law throughout the country, and that are very much essential. If you read the structuring of these provisions, which is pretty self-sustained, it's a beautiful draft, I would say. But of course, I'm given to understand that this law, this enactment, did not go through the normal process of debate and discourse on the same. which had led into a few, I would say, misgivings and shortcomings within the provisions, especially one that governs the penal provision that penalizes a person who is already on bail on a murder case, where the original provision of 303 was repealed by the Honorable Supreme Court as ultra virus because it's only provided death sentence, no alternate sentence. But now there is a provision, if I'm not wrong, as 103, 104, which says a person who has already been convicted for an offense of murder will be sentenced to life or death, which is same as the one which normally governs a punishment for murder. So therefore, there are certain gray areas, and there are provisions which are welcome, and there are provisions which are not that welcome. When 304A, rational negligence, death caused by rational negligence act, it's been given it's made a mountain has been made out of more than that. So much more shortcomings are there in the provision. As we go on, we discuss about all those things. But still, the change in name, yes, as earlier speakers said, it's unwarranted because ultimately one of the honorable judges of the Madras High Court said, I'll continue with what already is there in force. And further, even if you're going to abbreviate the provisions in English, so it doesn't make any sense. If you're going to call Bharatiya Nyaya Sanhita as BNS, it is going to be BNS. It's again English. It's no longer the language which they want to enforce. And it's not my mother tongue. Thank you.
Thanks very much. Again, very important questions there, especially in context of whether these laws are able to achieve the objectives that they set out to achieve, whether they will be able to reorganize the system or not, because increasing punishments, same or similar offences, the law mostly retaining from the IPC, whether Macaulay has really gone out or not is something that you will really have to figure out. Professor, you can figure out from that.
Actually, the application of law on the one side, understanding the law on the other side, implementing the law on the other side. Whenever we handle the classes to the police officer, they used to ask the question by saying that we have been trained to file an FIR based on the fact of the case. What is that they can do? Take an example. The police officers, those who are working in the rural area, police officers, they are working in an urban area. I think the police officers they will now know about it. That what kind of difficulties which they are facing while invoking the provision. The police officers, those who are working in the rural area, if you take at least 10 FIR, in which 7 to 8 FIRs or 6 to 7 in percentage aspect, even if you download it in the online, there are 3 sections which reflect. One is about 294B. Now it is termed as a 296B. Other one is about 323. That means it is about the voluntary personal. Now it is termed as a 150. Third one is 506 of ITC. Now it is termed as a 351 subclass 2 or 3, depends upon the nature of offences. It's more 4 or 5. Sometimes if you have a deadly weapon, instead of using 506/1, they use 506/2. Now you used to tell them by saying that you forget about 1 and 2, you go to 2 and 3. Why? Because it goes for a definition. This is the one area where this accused definitely will be acquitted. Why? Because in some FIR they used to mention by saying that in Tamil, Tahada Varthayalan. That means it's obscene word. Normally you have to use what exactly the obscene language is. Now you may pose the question and you have to accuse either the person who gave the complaint or the person who has written the complaint. For an example, if I'm a police officer or if I'm a person who is a lawyer, I know that the exact word is not used and what will be the difference. And the senior lawyers are here, you know that they can argue by saying what is the exact law. And another one they are saying, this is the provisions where in the new BNS, the voluminous power has been given to the police officer. If you read section 173 subclass 3 of BNSS, it is clearly says the offense if it is more than 3, but up to 7, the police officer has a right to conduct a preliminary inquiry. And previously, the offense is really a cognizance is made out. If you look at the CRPC 154, it is very clear the police officer has no business to do. And now, the provision has changed. Even the power has been given to the deputy superintendent of police, to get a permission before looking at this data. Why? Because normally there is a practice, if I do the complaint, because almost all the seniors are here, the parliamentary here, they do it well. If the police officer doesn't look into the matter, we use the provision section 36 of CRPC. That is a normal procedures we do. Now we apply section 30 of BNSS. The process, though there are some advantages and disadvantages, most of the provision has been retained. It's a challenge. And I asked the police officer, how you will recollect all those things? They used to say, sir, we have to normally keep it in our mind around 20 sections. Take an example, I said already 3, another one is 324, this is 323. Now if you read 324, 325, 326, 327, 328 of Indian Penal Code, they put it under 118 subclass, everything is merged. Subclass 1, subclass 2, subclass 3. And not only this, there is a difficulty while invoking section 217 of IPC and also section 337 of IPC. There is a difficulty is there. Why? Because normally in a rural area, if I go either in a vehicle or not, I will go to the police and say somebody gave me a vehicle, I got a injury, so that if understandings are not died, there is a process. You know, whenever I teach the law student, not in area teaching, I will go to the police station like an intern and see that how the process is going on. Normally what the police service will do, there is a report they have to do, our senior police officer, there is a report called DSR. When you go for DSR, they will tell, sir, this is an information that 279 and 337. I will ask why I think this is a 304A, why the person is studying. It is about the implementation, the practicality. Then they will tell, sir, you have to get a permission from the higher level, then only we can. At least 304A, we can call it. Now, even in that, I used to tell them, there is a trick using the 304 capital A. When you read 304 capital A on the one side, maximum punishment, while I was practicing before 20 years back, only 1 day punishment which you argued in the judicial magistrate court, only 1 day punishment also they gave it. Depends upon the common intention normally use it, whether they have an intention if you look at section 34 of IPC. Now it is there in section 3 subclass 5 of BNS. That is very clear cut of, that ideally use it. Now there is a problem by invoking the particular question. This was the fact that there is a debate and we vote on it. They put it like 106 subclass 1, 106 subclass 2, 106 you can call it 3. There are 3 kinds of punishment they are given. One is 5 years, another one is 2 years, another one is 10 years. That is what the process is all about. But we don't have a problem as far as the 5 years punishment is concerned. Why? Because they use a word called which may extend. Which may extend. They can give. The problem is in 2 years punishment. Why? Because the doctors are agitating. Well, because that 2 years is applicable only for the doctors. Then another agitation comes from all over the India. Why? Because the 10-year punishment didn't come. They are saying, when I ask them, sir, we have an intention to save the people. Once we come out and go, the people who surround us, they will get us. It doesn't mean that we are not human beings. We are also human beings. Sometimes the accident will happen like this. You have to look at this aspect. Another aspect is that whenever you find the case, there are 2 provisions you use it. When somebody who enter inside the house, That is routine process to the police officer. One is 457 of IPC and also 380 of IPC. Now it is termed as 331 of VNS and also 305 of VNS. That means theft in the dwelling house. In that aspect, many of them they are getting acquittal in the name of the flaw in the investigation. That is the reason why they added the provision like a criminal case of in the fund which is the petty offences. I also had a debate while using the community services. If you read that, there are six. One is section 202 of the VNS, another one is section 209 of VNS, third one is 226 of VNS, fourth one is about 355 of VNS, 51 is about 356 of VNS. This is the process normally we move for community service, in which there is a problem while using section 355 of VNS. Why? Because on the one side a drunken person, on the other side public place, third one is misuse. Normally what we do, we use the provision whenever the police officer is here, they discuss 353 of PC and also if you consume 4 surplus 1 AF Tamil Nadu provision. That is the process. While invoking this, the special law also will come. Then there will be a difficulty. Okay. Thank you.
Thanks very much, Professor. That's very interesting observations on how the framing of some of these provisions is going to operate, but lots of food for thought for us also in terms of now memorizing all of these new provisions. And Professor certainly has taken a lead on that. Really. Now I move back. Both Mr. Kandaswamy and Mr. Satyam had highlighted two provisions, one on the Terrorist Act and the other on organized crime. I would like both of y'all's views on a provision like this, which had already found place in a special legislation like Makoka and its Gujarat counterpart. With the idea, as far as I understand, having special laws is that these are special kinds of offences which may at times need special kind of procedures, special kind of trial procedures. Maybe there are requirements in terms of bail, we want to make stringent bail provisions. What is the value of having such provisions in an ordinary penal code, in a more substantive law? And how would they operate with the Makoka and the Gujarat law in operation? I understand there is a provision that has been added which says that the superintendent of police will have the authority to decide which case goes under which law. So just wanted your views on this.
Let us go to the intent of the legislation. Organized crime is coming up in a large way in the entire country, therefore it has to be dealt under the regular penal code, VNS. Not much of debate on that. The second part, what Dr. Memo says is very valid. We had a discussion with the officers in the NIA. So I'll make something very clear. Whether it is the UAPA, that is Unlawful Activities Prevention Act, or it's your 113 of the VNS, the definition, the punishment, everything is same, almost the same. Major provisions of the VNS have been taken from the UIP. There are some vital differences. For example, terrorist funding is not part of the game of the local police, meaning VNS doesn't care. Similarly, the other organizations like your society, there could be a friend organization doing very philanthropic work, but they could be involved in terrorist funding or terrorist activity. So those could be charged only by the UAPA. Whether it's UAPA or whether it's going to be the VNS, the procedures with regard to arrest formality is the same. It's basically your VNSS or CRPC, no change. Why these important sections are being left out to the VNS was primarily because, for example, terrorist funding, it's involving cryptocurrency, involving foreign country and how the money is going to come, 17, 18 layers. So you need an investigative agency which is specialized in nature, so therefore they left it out. But why did you bring in those concepts when it's not needed is the moot question of Dr. Memo. One is that we do not think that every terrorist is going to cause death or is going to cause some huge damage. This is defined in 113. There could be other forms of terrorism which can be held, which can be talked about, or which can be handled with the local police. Why unnecessarily burden them? And number two, if you do not give the authority or the local police to do it, they will completely show away. For example, I have XYZ job, and X job is going to involve in terrorists. I'll avoid. I won't go to that. So over a period of time, the law and order will deteriorate because they say it's not going to be my baby, it's going to be NIA or CBI, I don't care, or ATS or CBCID. The local police will not give much attention to these terrorist activities. When they know that they have the power to arrest, they can nip them in the bud. So that could also be perhaps the intent of the legislators, that local police should be empowered to investigate the terrorist activities, so that they're not only going to be very careful in preventing them, they're also vested the power to investigate. If it goes beyond the hands, certainly they can hand out the ATS, or they can hand out the NIA, because the provisions are there. But as of now, till RK Darikme, your NIA doesn't have these offences of BNS in the scheduled list. So now BNS is the area of local police. Have you clarified?
Yeah, again, an interesting insight from the police official. Here, the question would be this. See, Terrorist Act is now made an offense under the Nyaya Sanhita. Now, the question would be this. Ultimately, this terrorist act of terrorism should be investigated by the central agency because it is not confined to one geographic area. Because the masterminds are going to be elsewhere out of this country or within the country in one corner of the country. And the perpetrators would be in one corner. The middleman can be in another corner. Whether the state police can have jurisdiction over all the three, and the answer would be a simple no. So now there is a conflict. Who has to initiate an investigation? The investigation got to be initiated by the local agency, there's no doubt about it. Now, once it is initiated by the local agency, it is either for the government or for the agency itself can transfer the case to the UAP. There was a judgment by this Honorable High Court, a revisionary judgment, which gave out the modus and the prerequisites of a particular case to be transferred to UAP. So, this particular enactment enables the agency to decide. Once you make a call that an offense is an act of terrorism, then a provision of 113 can be added to the FIR. The moment provision of 113 is added to the FIR, it is for the NIA to take over the investigation and proceed on with the investigation. It is an enabling provision, I would say, which was not there in the IPC. Now made an enactment under the Nyaya Sanhita. So the question will be again, why do we need such an enactment? And the answer would be this. See, we cannot have a blindfolded thought process, that we don't need such one. We have already adequate. Here, the terrorism, as officer said, it has got many shapes. It has got many, it has metamorphosed into so many manifestations. So, under such circumstances, yes, this should be simplified and brought within the provisions of the enactment of the code that would enable the local police to place their hands on, which would further, it can be transferred on to the central agency to investigate in a better way. It is only the investigation to be done in a better way, the central agency will take over because they have more resources and more access to the places and the other aspects, the finance and other things. So apart from which, to be on a critical side, giving it a critical shape, whether these enactments can be misused, yeah, the obvious answer is yes, it can be misused. Because I'm not trying to malign the reputation of the police department. In my 26 years of experience as a defense lawyer, I've never been on the side of the prosecution, but for a few straight cases where I have defended the complainant. False implication is something which is imminent, which another friend is definitely not saying no. And the false implication is on the ground, either on nepotism, influence, and primarily monetary gratifications. So under such circumstances, whatever the enactments be, the, the very essence of those enactments have to be smelt the right way, only by the one who is going to enforce them. See, the moment they fail to enforce a particular thing in a righteous manner, and it becomes a playfield for a defense lawyer like us. So obviously we take those little, they cannot make a foolproof false implication. Every case will have a loop, wherein we take advantage of it and get along with the case. So therefore, the enactments are welcome, absolutely no doubt. But it is for the enforcers to make sure that they don't falsely implicate or misuse the powers that may be given.
Thanks very much. So very interesting ideas that there's no dispute that we need provisions such as these. And as Mr. Kandaswamy and Mr. Satyan also said, that we are able to distinguish between where the local police's overall should be and where those central agencies come in. But as a word of caution to Mr. Satyan, there are issues of misuse that have happened before, and that is where I think the real work will continue to be. And I think in a similar way, there is, in terms of misuse, comes to my head the offense of sedition, which is now being dropped, and another offense which is now been added is the offense against national integrity. Professor, from you, how do you think the framing of the provision is substantially different from the offense of sedition that was there in the earlier IPC? Specifically in context of course, because observations from the Supreme Court have been there. Period a few months back, they stay all trials under it, and at that time, of course, the government had said that they're proposing they'll be dropping the provision soon. Now, the provision that replaces it, do you think it's substantially different, and does it really address the concerns that the provision of sedition had at that time raised? Because this is, I think, one of the more crucial aspects also when it comes to the idea of decolonization. Because provisions like these came up in a particular context back in the 19th century, and continuing with them in what way and how they are used is very critical for us to understand.
Normally, when we use the provision of sedition, we have to look back how it was used against other people. Take an example, Balagangadhara Tilak, Vavu Chidambaram Pillai, Mahatma Gandhi. List goes. Because a colonial system where whoever speaks against the government, they may feel that it's like a threat for them, but they will use the word like a sovereignty as a trump card for them to file a case against them. It is not for us it was enacted, it is for them, but for welfare it was enacted. Normally what will happen, I will tell you, whoever speaks against any sovereignty, they put it under Article 19 subclass 2 by saying that you don't have any right. Why? Because there is a restriction under Article 19 subclass 2. But if you want to come out of it, you have to. On the other side, when you look at the provisions, there is a case long back for this edition. There are two cases. One is the Tara Singh, other one is Kedarnath versus the famous cases. Then only we slowly understand how the sedition law has been issued. Even 2005, 2010, for an example I will tell you, as a law professor, if I go and settle in a hills area, or in the area where the Maoist is dominated, or the area where the Naxalite is dominated, our intention is not to support them. Our intention is to tell them that you come to the democratic way so that the government is ready to help. You know what will happen? There are cases, because if it's 100 cases, not 100 cases are false cases. Few cases has been filed against the people who is really his intentions well and good, Not to support the Naxalite, not to support the Maoist, but to raise them that we have a democratic country. And there are cases where I can say the sedition is a trump card, but to what extent it is really a purpose for which it has been used. If you look at the section 156 of BNS, it's very clear. But the word they use it intention, sovereignty, unity, democratic. Because the same word, it's quite interesting to me when I read this. The same word and languages they used it, even in the languages and unity, integrity and all. You know, little bit in a section 103 surplus 2. This is the way in which the sedition law has been used. Now what they have turned it, that's quite interesting thing you should know. Sometimes if I speak against the government, they use that not I am speaking against the government, but I am speaking against a particular religion. So that if the authority feels that the case has been opened against me, if they feel that it's not wanted to the A, and they can file a case against me, that for example I am saying, under 153 capital A. That is a famous provision actually, normally I use it. Now it is done as 186, that is the process. The simple answer is whether the sedition law is misused or not. Yes, in certain extent it is misused. That is the reason why the Supreme Court has noticed to file a case. And another one, to what extent section 150 would be the reality or not, that is also a question. Sometimes there is a possibility that it also will be misused. I think one point.
The provision that is sought to replace sedition law, though the words that I use, like endangering sovereignty, unity, and integrity of India. Now, if you read the recital of the language, whoever purposely or knowingly by words, either spoken or written, or by signs or by visible representation, by electronic communication or by use of financial or otherwise, excites or attempts to excite secession or armed rebellion or subversive activities, encourage feelings of separatist activities and endanger sovereignty, so on. So it goes on like this. See, there is an explanation to one. It says, comments expressing disapprobation of the measures or administrative or other action of the government with a view to obtain their alteration by lawful means without exciting or attempting to excite activities referred to the section do not constitute an offense. There is a safeguard, innate safeguard that is provided under 152. But this 152 is, I would say, in my opinion, is a need of the hour because they have brought in the word visible representation or by electronic communication. If you open YouTube, the so-called YouTubers who talk on so many social issues, they go a step beyond. And not only, to express themselves, maybe the point of view is correct, but the manner in which they really try to strike a kind of a discord between, because there's so much of filth in their content, and obviously there must be some law that should come into force to curb that, because as of now, we do not have any censorship so far as YouTube or anything is concerned. But there must be some safety, innate safety that should provide some kind of normalcy and harmony in society. You cannot keep slinging mud onto a particular community, one community on the other, which is quite rampant. So 152, in a way, is a welcome one. But I think it's a subjective one because whether it can be misused or otherwise,
Thank you, Mr.
And sometimes what will happen, in addition to these normally, which provision you use it normally, find out for. That is a famous case, Mahova's speech. There is a word called intent to get a bit of peace. And that is the reason why I slightly pointed by the senior counsel. But there should be a limitation in everything, because there should be a possibility where the social media speaks too much, and also has to be controlled to the next. Then this will be a really a trump for that.
So, control seems to be the broader theme that is emerging, the emerging need for control, specifically with internet and other means of communications coming up. But my sense, my view on this has been that there is a central tenet of criminal laws that you have to write them very clearly, very specifically, so that each and every individual is aware of what they can actually go to jail for. A framing which is wide for interpretation may be helpful, may be enabling for a police officer to really take the call whether they want to prevent an offense from being committed or they want to take control of the situation. But they also leave a lot of room for misuse, which is what has also been flagged here. And I wanted to reiterate this because a lot of these words, as the Professor also highlighted, were being used in a context because they allowed their interpretation to be wide. Sovereignty, expressing dissatisfaction, disapprobation, things like that in the previous provision, and now exciting feelings of secession and separatism. Provisions like that may also have a very wide connotation, but there may be a need for that to be there, but how they are used is something that we have to be very careful about. And this is where I would like to have Mr. Kandaswamy's views. How does a police officer really take the call? Because it's very difficult to draw the line between what could amount to an offense against national integrity and what could not amount to an offense against national integrity. Isn't this too big a burden to be? Because once you set the criminal the justice system in motion, once an FIR is lodged, then the process itself tends to become punishment. You have pending trials for 1 year, 2 years in prison. That's precisely what happened in cases of sedition. So just wanted to have your opinion on how important it is for that police officer who's investigating this act, and for him to be able to take a call on whether this falls squarely under this offense or not.
First of all, I should inform you that this particular section or certain other sections, though they may appear on the statute book, it is not that the SSO can take a fair and write it. There are standing orders, there are guidelines with the government where they have made some statutory provisions that you need to get this particular approval of the public prosecutor, you've got to get the approval of the Home Secretary or Chief Secretary or DGP. Certain procedures are put in place so that the lower level functionary of the police is not put to unnecessary discretionary powers and cause harm. That said, whatever may be the superstructure you are creating, at the end of the day, it's only the political executive decides. Okay? So therefore, all these mechanisms are only to see that some amount of individuality is not there, but the government is reflected. If a particular government power is going to misuse that, I'm sure the Honorable High Court, Supreme Court, over the period of time, as the law evolves, either find any inadequacies, subject of abuse, like how the Tara was struck down, or how the other provisions of the laws were struck down. Similarly, this also will be struck down in case any abuse of this kind were anticipated.
Very significant point that there are inbuilt checks and balances in the system that can actually take over when there are concerns such as misuse that come up. One issue that also comes to my mind is that there are changes in how now the preliminary inquiry is supposed to be conducted. And this is, I think, introduced. Sorry. Yes, just wanted your views on this.
It's a very, very important topic. If a victim is affected, he goes to the police station, he or she goes to the police station. They want a FIR to be registered if a cognizant offense is relieved. That is the law of the land, 154 CRPC. At the beginning, I informed you that this BNS has done some new thing by codification of the Supreme Court judgment. One such thing is Lalita Government's judgment, where at the drop of the hat, FIR need not be registered. The police officers can conduct preliminary inquiry in Lalita Government's judgment. There are some specific corruption cases, or when cases when something is not very clear, white collar offences, evidence is not open. So in such cases, Lalita Government judgment gave power to the police officers to conduct inquiry. Though as per say 154 CRPC, police has no discretion at all. They have to their fair. That's what Dr. Raja Venkateshwar told. As a practitioner who has been there for 3-4 decades in the police, you have to trust the police that we need to give them the powers to conduct preliminary inquiry. That way, frivolous petitions are not entertained and result in FIR. Number two, FIR is double-edged sword. Once FIR is registered, the person who could be innocent could be intimidated, will be arrested. You need to go to the court, get a direction to arrest the accused. So many problems are there when FIR itself is wrongly registered because no proper inquiry was done. So therefore, seeing the new provisions, I think, not sure about 173. There it says that police or the rank of DYS, Deputy Superintendent of Police, can conduct a preliminary inquiry. They give some days of 15 days, 7 days, 14 days. And if inquiry reveals the causes of offense, FIR can be registered. I think it's a fair deal. In my opinion, it's a win-win situation for all of us. The victim, the accused, the police officers. Police officer not open, accused not unnecessarily threatened, victim is not given a go by.
I have a little difference of opinion on this. Because as a defense lawyer, I find it a bit easy for me to defend an accused, rather be a lawyer for a complainant, to run from pillar to post to get a case registered. See, the thing here is very important. Here, it is the station house officer, now is the inspector of police. He is the one who decides whether the case can be registered, whether the cognizance can be taken on the case. Take, for example, a simple case of 420. Now, we have seen so many complaints where the crux of the complaint would be the person borrowed money and he failed to repay the same. Time and again, the Supreme Court has said this does not constitute an offense under 420. But the police, very, judiciously they register an affair. And we come immediately to the High Court to get the case quashed. And I think my senior Mr. Justice Dasha would have quashed at least 1,000 affairs of this nature. So, there must be some strict rules. The officer was talking about the PSOs. PSOs are beyond directory, they are not obligated, they are not mandatory to be followed. Now, this small leeways that are provided to the police give rise to a lot of room and scope for corruption. I'm sorry to say, you was the head of the DVACS. So here, this is where corruption comes. An officer who's bound to register a case, if a cognizable offense is made up, stop short of registering a case for certain monetary obligations, and that's the starting point of a corruption. A normal 420, if the amount is going to be in a few crores, the complainant wouldn't mind coming to the police, paying a few thousands, or maybe in lakhs if it's going to run in crores, get the FIR registered, arm twist the accused to repay the amount. But if he's going to go to a civil court, file a suit, of course, there are suits which can be completed because I'm not an authority on civil law. I'm not a civil lawyer, by the way, I declare myself. If that time span, the delay, that could be avoided by going to the police and arm twist the person to submit. On force into the police station, arrest, which is the prerogative of the police. The police can't even say anything about an arrest unless it's protected by an order of anticipatory way. Then in such an event, there is again an abuse. So this preliminary investigation gives rise a room for a misuse. Again, there is a bargain that's normally done in police stations. Because it's been quite some time since I've been to a police station, it's almost a decade or more, where we have seen in our own eyes, these are practical issues. Now, from an officer's point of view, he has to take this part. I'm not against that. As an academician, being a practicing lawyer, turning an academician, he may not say certain things. But being a defense lawyer, it's my duty to bring forth that getting a case registered is not easy. For a case where there are apparent elements or ingredients of an offense is made up, the police will refrain. Now, the judgments of the Honorable Supreme Court say, no, you cannot come to the court by way of 482 or 226 to get a case registered. Now you have to take circuitous route of going to the trial court, go file a petition of 156 clause 3, then get it registered and then go come before the court. That's not going to happen. And the powers that are given to the police. We have seen honest officers, even at the level of inspectors and sub-inspectors, without any obligation, without even looking at your face. The offense is made out of the complaint, the case is registered, they proceed on, arrest the accused, they do everything that is good for the complainant. But they are not the majority, unfortunately. Some way or the other they slip. So therefore, these procedural things, it requires, there is again the change in the mindset of the people. So yesterday, the day before yesterday, I was not here, I was in a country where the rules and laws are strictly enforced. And not the driver, they called him the coach captain. And she was saying, here, there is no corruption, the police are not corrupt. If you're caught for violating, you're fine. That was the pride that the coach captain was carrying on by saying, my police is not corrupt. Can we say that? Would be a debatable one.
I slightly differ from the Defense Council. Why? Because the practice is totally different from what we are doing before the Code of Law in some extent, not 100%. When you go for an example, internship to the police station, normally I used to tell all my law students, go to the police station, go to the SP office, go to the taluk office, go to the police station, know about how the law has to be implemented. For an example, in a rural or particular village, whether it is a civil matter, whether it is a criminal matter, they have a faith in the police. Even for borrowing the money or lending the money, many of them who gave the money, they are in the jail. Why? Because the system is like that. I will tell you, recently the case, for an example, if I give the money and go and ask the person, he will tell. If I ask with me, I will go to the police station with a lawyer, craft a complaint that it will always look like a cognizable offense. Cognizable offense. The police has no power. The next day, police will say, sir, the case has been filed against you. Why? Because it made out the cognizable offense. Even if you give the money, you have no problem. We should see. Other side, what the police will do in some extent, I will tell you. Just because, the police do something general, that doesn't mean that you cannot paint the entire system. There is a safety and security for the public. If you read the section 217 and 218 of IPC, now it is turned as a 255, 257 VMLS. The police also doesn't have any power to save any person. Even the police also doesn't have any power to make incorrect attack. If they do so, the case has been booked against the police officers also. Even there are cases like the honor killing and other cases where the police officer also got a life imprisonment. Another one, it already happened. Even if it is a civil dispute, the nature is also like a civil dispute. What the police will do? Conduct a criminal investigation. Give some time to the police officer to conduct a criminal investigation. First of all, the complainant will ask the police, sir, I gave the complaint. You do what you want to do. They will issue the CSR. They issue the CSR, finally call upon the both parties. Even if they made out the civil dispute and the national civil dispute, they will say it in Tamil by saying that in the Puvar, உரிமையில் சம்பந்தப்பட்டதாக இருப்பதால் உரிமையை நீதிமன்றத்தை அணுகுவதற்கு நாங்கள் உங்களை பரிசோதிக்கிறோம். That means it seems like a civil dispute, so that you are requested to go to the civil court or approach the civil court. Why? Because I will tell you one thing. Most of the police officers have been suspended. Why? Because even the civil dispute, both parties will fight within themselves. One person will die. Then what will happen? It is like a dereliction of duty. Dereliction of duty on the part of whom? On the part of the police officer. See, you cannot blindly paint by saying that, the police officer is corrupted, the police officer is known they are creating fabricated document. For an example, one or two situations maybe, but we are not totally denying on that. But in a totally, you have to understand the reality. The reality, maybe 10 or 20, I am not fully supporting the police system. But 50 to 60, there is unique cases where the innocent people can be saved.
I'm sorry to intervene. This is not a forum for us, this is police and non-police. It is specifically with regard to the features of DNA. Let us restrict to that. If our learned John Satyan is citizen, I can be counter argument, it will be endless. poor audience will be suffering, Honorable Justice also will be forced to listen. So let's avoid that. Let's move to something else, Mr. Moderator.
Yeah, no, I'm not trying to blame the system, please. I think he is getting offended. I'm not saying that the entire system is corrupt. I'm taking there are weeds in the system. These weeds are the one who try to project an image that the law is absolutely a waste. That is what I'm trying to impress upon. Secondly, the question would be, once the complaint is lodged, this is on legal aspect, once the complaint is lodged, the preliminary inquiry is, you cannot summon both, because a person who is accused of an offense can be summoned under 41A. The 41A can be issued only on registration of the case, not prior to that. That is very law. So therefore, you cannot summon both the complainant and the accused to the police station, do a panchayat there and thereafter settle the issue. You are not duty bound to do that. Your main objective is to make sure once the complaint is received, if the complaint discloses compensable offense, there's absolutely no issue. If it doesn't, the complainant is called. He is asked to come with material to substantiate his complaint, so an offense is made. So therefore, if it is a civil complaint is civil in nature, it's a civil in nature. It doesn't mean to say that the cases which has the colors of a civil thing has certain elements of criminality, yeah, you can go ahead and register it. And secondly, I have also said there's a scope for corruption. That's, I didn't mean to see, I have so many police officials. I've depended from a rank of a DGP to a police constable. So I know where to log a crime. So therefore, I'm not blaming, let him not get offended. I'll stand up fairly and say, if I don't have a case, I don't have a case. So
it's always good to have different opinions. It always helps us build that perspective around laws and how they are working. Now, it'd be great to have your closing comments on this. The thrust of these laws is that they're decolonizing. And to my mind, and we go through the literature on this, it tells you that the system was carefully curated back in the 1800s, middle of the 1800s, Macaulay and the first Law Commission. It shaped the way we were drafting our provisions. We discussed the offense of sedition, the offense of enmity between groups, the way we were using preventive detention, the way police powers were designed, the powers of arrest were designed and how they were used during that time. The way punishments were thought of very carefully, why transportation would be relevant for a community such as this, because it was seen badly from a religious and societal point of view. So there was a different viewpoint that this colonial administration had for India. They may have had different agendas, and criminal law was a tool to achieve all of those things. It was not just a tool to ensure public order. Quick comments from all of you in terms of, do we really feel that these laws have gone ahead, and is there scope to truly decolonize India's criminal justice system from all fronts? Could be prisons, could be policing, could be judiciary, and could be from how the laws have been written. We can start from Mr.
I mean, it's really fair that anything the government does it, everybody's strength is different. The way I look at it is different, the way you look at it is different, the way Professor K looks at it is different. So certainly, there are a lot of perspectives which is saying that it is primarily towards X objective or Y objective. But let me be very fair. I'm basically an engineer and now in management. I'm purely seeing from the point of view of how the law is from an impartial observer point of view. I think fairly the law is very good. It does address the concerns of the changing society, the needs of the hour, how the entire Indian society is changing, economic dimension, technological innovations. But in the opening remarks, you made a very valid comment that also I should acknowledge. The law that is framed now, I'm not sure whether the infrastructure will take care of that. Certainly, the big gap between the law and the infrastructure. So that has to be addressed. Whether they give 5,000 crores or 5 million crores, that's a different matter. That I should acknowledge. The law is very good. There are some gray areas, there are objectivities, difficulties. Those things will be stuck down or will get evolved over a period of time. Let us give the devil's due.
My point of view insofar as certain provisions, and I have my own reservations on certain provisions, especially one under 106 causing death by negligence, which I've been time and again reiterating that. It says it enhances the punishment to 5 years from 2 years. See here, a death caused by negligence, there is lack of intention and lack of knowledge. It is an accident simpliciter. Of course, accident simpliciter is also provided under the general exceptions, which now club. Now here, enhancing the punishment to 5 years is a little too much to my opinion. And secondly, bringing in the doctors within the ambit of 106 and specifically saying if something goes wrong, then you will be punished under section 106, which goes against the spirit of the judgments of the Honorable Supreme Court, which says the negligence must be gross in nature. The legislatures never considered that point, which because the Supreme Court time and again said, this is not a mere negligence that would bring in the doctors in the purview of 304A, which is likely to go out. It is the gross negligence that is to be decided. The grossness has to be decided by a competent authority or by a team of doctors, which is lacking in this provision. That is one thing very important. And secondly, the subclause to it, whoever causes death by death and tries to escape. Now again, escaping is a little bit, I may fear assault at the place of offense. He was talking about it, Professor was talking about it. So I may run. Whether that a time gap, whether it's going to be an hour's time or a couple of hours time, it's a relative one. Whether I can be brought in the purview of 304 Part 2 and extend my sentence to 10 years again would be again a debatable one. There are two things. Thirdly, in general, the law is good. As he said, every other word is subject to interpretation by the Honorable Supreme Court, the Constitutional Court, the very High Court or by the Supreme Court. And again, it's a march of law. It progresses. What is good today, tomorrow, Constitutional bench is over it and say it's bad law. So ultimately, the stakeholders to the provisions, one being the enforcers, the judiciary, in between the lawyers, the academicians who are going to teach, make us what we are today. So the stakeholders are there. Now you see 3 different viewpoints amongst us, and there's going to be a million. And whether all these things were debated on the floor before it was enacted, maybe it could be a cause for all these anomalies that are present. That's my position.
If you read overall the VNS or VNSs and also VSA, there are provisions like offences against the women, offences against the children, offences against the state, and also there are some petty offences. Take an example, section 65 of VNS, where gives the maximum punishment to the person like a death sentence. That they have no committed offence against the children who is below the age of 12. And also there is an enhanced punishment under section 70 of the VNS, gang rape. If the children who is below the age of 8, that means now the previous provision that previously it was 16. That is why most of the people they used to know of 366A of Indian Penal Code, now it is 96 of VNS. Now, if someone who is below the age of 18 would be convicted. So that even in that case for gang rape, this sentence has to be avoided. For others, it is only shall not be less than 20 years. That is the provision. These are all the provisions where enhancing punishment in order to protect the women, protect the children, protect the downtrodden would be a very step. On the other side, there are provisions where normally I used to tell jovially to students, whenever I see the ambulance here and after, I have to think about section 306 of Admissibility. That means 306 is called as a 108, abatement to commit suicide. No, not that is the reason. Then only the student will easily understand. Otherwise, the recollecting section is very difficult for them. There are provisions where it gives the power to the citizens also to ask the questions against the official. And there are provisions in VMLS also with regard to the custody, and the judicial custody, and remand. Why? Because I will tell you that recently I read one FIR where nobody died. Normally the police officer, what they will do, file an FIR under section 511 of 5 PC, 306 of 5 PC. Sometime even the code take the photo, later on it is uploaded in the social media, section 67 subclass A of information technology. We had a healthy argument. But nowadays those confusions have been out by saying it's very clear in certain provisions. What is the offense? What is the punishment? But as I pointed out from our let the court to decide in case there is any confusion. So this is the initial stage. But we have to welcome the all three legislation. Why? Because when the time change, we have to accept certain things. But the law should be suitable for us. If not, let the court to decide which one will be suitable for us.
Thanks very much. We'll close this session with that. Those wonderful insights from all. We can perhaps take a couple of questions and then yeah, we have a question there. If you can have a mic.
Thank you. So thank you so much for your insightful comments and inputs on the. Can you hear me? Yep. Right. So my comment is with regard to something which was mentioned earlier in that committee of panel discussion, but which unfortunately was not substantiated later on, which is about community service and whether there has been actually enough like there's enough codification in PNS which would help in actually understanding what is community service and how it could be implemented. Now, this is not the first attempt that the first attempt of introducing community service in India. In 1976, there was a bill which was actually passed in Rajya Sabha, but it passed in Rajya Sabha, Lok Sabha, and it lapsed because Lok Sabha was dissolved, so it could not be done the next year. Right? And that was, in fact, a much better codification compared to what we have here at the current moment. At that time, the codification was that the community service hour will be limited to between 40 hours to 1,000 hours. So the judges will have an idea that okay, you have to range the community service between 40 and 100 hours. You don't go beyond that. So they have to act within this limit. The second was that whenever you give community service, you have to consider that the person who is going to serve the community service could actually serve that service. If you're giving a community order to someone who is not in a position to do what they're asked to do, there is no point in giving community service. Second, but if you see this current, there's nothing which says about what this would actually mean. Second point is that in 1996, 1997, there was a law commission report which commented on whether community service will be good for India or not. And they very categorically said that it's not a good fit for India. Unfortunately, they have never gotten back to understand why law commission thought so, which is a very poor attempt, and which shows how bad this attempt is in making criminal laws. And like not to be bit more negative, but in India, the parliamentary process has been very sketchy in terms of how they approach criminal laws and making changes in criminal laws. They have not given why they're making a change. They just make change and hope that it works out. Community service is a problem. That if you see England and New Zealand, which have community service, they tell you how to implement community service. What if someone is not following this? What if that process is not followed? What if someone is not going towards community service and is fine with paying fine? Now, in theft, there is an offense for which only community service is a punishment available. VMLS does not say anything about what happens if that person is not following that community service order. If you go back to judges to get
we can restrict that question.
Just now. So if you go back to judges to make that correction, then what's the point of bringing community service? You're not doing anything good. It's just a fancy word to say, okay, community service, and then we're doing good, but it's not a community service at all because it's just more time, more waste, nothing good. That's all. So what do you thought about how this could be addressed?
Thank you.
What was your question?
The question, if I can summarize, is that the law, of course, introduces community service as a form of punishment, prescribes it for six offences to be precise, but as an alternative to, but it doesn't really lay down what it should, what it would mean, and how do you really go about executing it.
So I'll take a lead on it. Okay, community service, in the sense, for a petty theft, a community service is provided as a punishment. As you said, what relevance that it's going to have on the offender and on the society at large would be the first question. As I said, had this been debated at various stages, then all these questions that you have put forth to us would have been answered one day. For a thief who commits a petty theft, this community service is not a punishment at all. For a person who's from a higher strata in society, if he commits an offense, for him, community service will have an impact. But a hardened criminal who doesn't give a damn about nothing about going to the prison for 15 days, this community service has got no relevance, and this provision of community service, as you said, may not have relevance to the society, especially where there is disparity in almost everything: education, economics, everything, social, fiscal, so on and so forth. So under such circumstances, as you said, community service is not going to be of any relevance that's been provided. But before you said, you should introduce yourself before asking questions. That would be it. Your name, where you're from, what you do, from the perspective that you get.
I'm Ashwani Singh. I teach at VMLS.
You teach at VMLS. Good. You'll make a good teacher.
I completely agree with Mr. Satyan. See, you have to understand that the law has been totally punitive. They're making a first step towards community service. Even here, they are being quite careful. Even petty offense, first offender, money has been returned to the person, only then community service is there. But as rightly said by Dr. Nambooz initially, we have not created an infrastructure. Who is going to oversee the community service? What's going to be the apparatus? How it's going to be done? What's going to be done the executive, judiciary, or the police? All those things are not very clear. I only hope that this is an act that we rules following, certain guidelines following, then perhaps something we put in place. That's what happened to most of the acts. Let's not jump to the conclusion now, nothing is there. Let's think it's the first step towards a larger goal. And again, from the perspective of penology or jurisprudence, whether this particular punishment deserve community service or not, is again a very important question that has not been discussed at the various forums, right in the parliament, till the various JPCs. So we do not know. But now that the act has been passed, let us assume that it's all done, and let us presume that there will be some apparatus put in place, something will take care, and let's hope for the best. But certainly, presently, it is not fulfilling whatever we wish for.
Thank you. Can we take another question? Yeah, there's one more question. One more question.
Hello.
Sir, my name is Prakash Swami. I'm a senior journalist. I'm not sure, please correct me if I'm wrong. Our legal system is gender biased. I think it's against men. We have a National Commission of Women, but we don't have a National Commission for men. In many of the domestic violence cases, men are put to hardship. They are being abused and tormented. Their whole life has been, I'm not talking about this, as a journalist, I come across various aspects. There is no National Commission of Women where people can go and represent. For example, if the woman is really being targeted, the man should be hanged, no doubt about it. But a woman can go to a police station, file a molestation complaint or a sexual harassment complaint, immediate arrest, no inquiry. FIR, prison, then inquiry. In dowry case, if there's a fight between husband and wife, but some kind of, you don't take me to movies, you didn't take me, she goes and gives a complaint, dowry harassment. Father-in-law, mother-in-law, brother-in-law, sister-in-law, husband goes to jail. He comes to the flash news where the Swami and Mandavali arrested for dowry harassment. When he's acquitted, no news is good news. Do you think that the law, we expected that the new law which is being, all the Hindi tamashas, will address the issue of men's rights in this country? We are Indians. We are part of this country. We have equal rights. When women ask for equal rights, it's time men ask for equal rights, at least in law.
I'm really glad that we had a very popular question that's come up. So I think let him be the campaigner for the cause. So let him start a movement so that some enactments are made saying there's because of people straight away from that.
I think one of the objects of the law is like,
This is a male-dominated society.
Exactly. So
I think that answers
Women are victimized.
that answers it.
You know the problem, you don't know.
That was diluted. Lot of female domination is going there.
I think that actually answers it.
Yeah, that's
It's a male-dominated society, and there is protection that we have to ensure.
I don't add much for this academic interest. There have been many laws that have been changed, made gender neutral. I don't run through the laws because already paucity of time. For the gentleman asked a very valid question. They have made it gender neutral. Not all sections, some sections.
because Justice Jen Vinayaka used to say this. In IPC, man means woman except in those provisions where it's described or defined. So man means woman. That's what he says. So he is being the master of criminal law. So we used to admire him.
Thank you. I think we can.
Most of the provision, if you read it, the offense is a human, it's not misuse in all cases. Human phone in jail, we have a action now it's done as a 83. If you read it from section 80 of 85 of VMLS, though there are provisions given to drug women, then and that there will be an exception, so that we can have integrity. But there are certain cases you have to see. I will tell you one thing: in a few cases where the name of dowry prohibition, one or two, but most of the cases in the dowry prohibition, women are affected, so that we should not entirely claim that it is misused.
Due to positive. Okay, I think there's one question then.
Last minute.
It is less of a question and more of an observation. I think the lack of women on the dais would probably answer his question.
Great point. Great point. Great point. I think. Thanks very much. Thanks. It was a pleasure speaking to you.
Thank you, thank you. I think that was a very powerful session with different perspectives, literally. Thank you. I now invite Mr. Surana partner, to felicitate Mr. P. Kandaswamy. Thank you, sir. I now request Mr. Ranjit Kumar, Senior Associate, Surana, to felicitate Mr. John Satya. Thank you, sir. I now request Mr. Shivatsan, Associate, Surana, to felicitate Dr. PRL Raju. Thank you all. Now let's break for lunch, and the lunch are arranged outside the auditorium for all the guests. I request you all to assemble back at 2 for the next session.
ಅಲ್ಲ ಕಪ್ಪು ಸಸ್ಯೆಲ್ಲ ಇರ್ತದಲ್ಲ
Good afternoon, everyone. May I request the guests to kindly move forward and occupy the front seats, please. Or the other end. This is announcement 2 to remind that we will be starting the session at 2:15. Ladies and gentlemen, a very good afternoon to all of you. We will now move on to our next session, which is going to be on procedural justice. This session will be moderated by Dr. Pomina, Assistant Dean and Assistant Professor at Vinayaka Missions Law School. She holds a PhD in International Humanitarian Law and has extensive academic experience from various prestigious institutions. We're happy to have her in the panel. On the panel, we were also supposed to have Honorable Dr. Justice S. Vimala, retired judge of Madras High Court. We've been informed now that due to some emergency, she's not able to attend. On the panel next, we have Ms. Ramya Subramanian, advocate, who has vast experience in civil, criminal, commercial disputes, focusing mainly on white-collar crimes. She graduated from National School of Law, India University, Bangalore, and leads the Chennai litigation practice at Astis Legal. May I request Ms. Ramya Subramanian to kindly take us seat at the stage. Along with her is Mr. P.S.S. Gauri Shankar, Assistant Professor at Satyabama School of Law. He brings over 8 years of teaching expertise, specializing in criminal law. His dynamic contributions include organizing moot court competitions, workshops, exemplifying his leadership in practical legal education. I now request Mr. P.S. Gauri Shankar to kindly move up to the stage. Thank you all. Over to you, ma'am.
Thank you. I welcome everyone here from Vinayaka Mission Law School on behalf of Vinayaka Mission Law School. Thank you all for being here, and I hope we will start this session chairing with two persons here. One is from the academic background and one is from the practical background. So as you all heard about colonization, and we also had a previous panel speaking about terrorism and other things. So this panel will all revolve around the procedural justice, that is criminal justice. So this DNSS, I would also go to the colonial era only because I am very flexible with saying criminal procedure code rather saying the terminology that is not even, I don't want to speak. Okay, so moving into it, the few changes that we've got is modernization, where we also speak about the victim-centered focus, and also it also speaks on the enhancement of rights. So I would like our panelists, Ramya, to open the floor and then following Gauri Shah.
Hi. So, in terms of changes, I think that is what would be most relevant to speak about. In terms of changes from a very practice perspective, I don't see too many changes that have been introduced. It is more so a restriction of rights on the defense side, and most of everything else has simply been codified. It has not been a case where anything too new has been introduced. For instance, now they say you can collect forensic evidence, you can do forensic data, etc. All of this, you can collect voice samples, fingerprints, and everything, not only from the accused, but anybody who wants to be investigated. This was already the position in 2019, when the Supreme Court had said a judicial magistrate may pass an order to collect all of these samples from a person who is being investigated. So this was already a broad right that was given. Again, it has been codified. Similarly, they say, now you can place FIRs online, and no matter where the offence has happened, the FIR has to be registered. This again, concept of zero FIR was already there. And in terms of registering the FIR online, I'm not sure about other states, but in Tamil Nadu, you could already do that. There was a citizens portal where not only can you register your own FIR, you can also take out data pertaining to other FIRs. Therefore, in terms of electronic introduction of registering FIRs or this forensic, I don't see anything too new. The only things that I see are super new are the bail provisions, which have significantly reduced the rights that were available to under trials. Now, what is going to happen because of this is now under trials have been charged under multiple laws. Say, for instance, it's a regular practice for a lot of people to charge a person under PMLA as well as the SSIA, the Companies Act. People who have been charged under both these laws, now even if they complete half the period of the imprisonment that they could have been awarded, they are not going to be able to get out. There's going to be a significant increase in the number of under trials who are going to be there, which according to a report is already 76%. So what's going to happen because of this is bail is going to be denied and under trials are going to increase. And now what they say is that because of that we finish trial very quickly. We finish trial within a separate time frame. We make you give judgments within 30 to 45 days. I mean, in theory it is great. But what is going to happen is that there are no new judges who are being appointed. So all the old cases under the old CRPC, they are going to go on and on and on for years and years. Because precedence is going to be given by judges to cases that come up after July 1st, where there is a specific time limit. So what's going to happen is that the burden is going to increase a lot, and judges are now going to be able to pass orders in 30-45 days. So the question now is, what is the consequence of that change? How are you going to sort of implement it? There is nothing. For instance, if an arbitrator doesn't complete an arbitration within the specific time frame, his mandate can be terminated. But what are you going to do with the magistrate? What are you going to do with the judge? How are you going to sort of implement it? So these are all sort of things, although they say, we've introduced something new, we've codified A, B, C, D, E, we've reduced the time limit for trial. In practice, I don't see it happening. So, for introduction, that's it.
Okay, and this can move to Gauri. From the academic perspective, you can also share your thoughts.
Thank you so much, ma'am, and good afternoon all. Thank you, Surana, sir, for the opportunity. And yes, when we are looking into the legislation, when it comes to the whether it is going to be an amendment or whether it is going to be a new enactment or enforcement, we should see the objectives of the legislation and what is the purpose of the legislation. So when it comes to this particular legislation, BNNSS, to address the issue in a delay in justice due to the complex procedures, due to the large pendency of cases in the court and low conviction rate, and also the low level of use of technology. The most important aspect when it comes to the Bharatiya Nagarik Suraksha Sanhita is to introducing the electronic evidences. And the most importantly, when it comes to the section 2(1)(a), it includes audio-video recording as well as audio-video electronic evidences and also the electronic communications. Like as my co-speaker said, panelist, it is very evident There were the provisions in CRPC which included, and as well as there were provisions in Indian Evidence Act which included electronic evidences and also electronic communicating evidences. Now we have to know why they are implementing the DNSS in around the 531 sections. Like CRPC was a 484 sections. The only change is the number of sections, but no changes in the implementations. I think very firstly I have to address about the name of the code itself. Like I'm going to use the term code in a legislation because every provision is talking about the this Sanhita states. In fact, we have to address it as this code says, but no more even across the India, every citizen is going to address this particular act as a Bharatiya Nagarik Suraksha Sanhita, according to this Sanhita. So, without knowing the meaning, we are going to use the term Sanhita. That itself a huge violation according to the Article 348 of the Indian Constitution, where the English should be the language of the law. But in that particular aspect, because this particular legislation is violating, and when it comes to the changes, we have a few changes. They have excluded the metropolitan magistrate. There is no metropolitan magistrate in new legislation, and there is no judicial magistrate clause 3 in this legislation. And they have introduced. In fact, they have modified the few powers of the authorities, like the JM1. The pecuniary restraint, the fine which can be imposed by the JM1, increased from 10,000 to the 50,000, and JM2 increased from 5,000 to the 10,000, and few other inclusions and few positive inclusions is like general neutral provisions. Like when it comes to the issuance of the summons, in CRPC, the summons can be received only by the adult male of the family. But when it comes to this DNSS, now they have included adult member of the family, which is adult person of the family. So this is one of the most important change. And when it comes to the establishment and when it comes to the using of the terms like a lunatic person, they have changed it as another term which gives more reputation to the person. For example, when it comes to the lunatic establishment, now they have made a change as the most important change in that particular aspect is intellectual disability, and they have changed it as changed the lunatic asylum as a mental health establishment. So all these kind of positive changes are there in BNSS, but there are few lacunas, and I will be rest with this for the upcoming session.
Thank you. My question would be like, what do you think about the handcuffing that has been included?
Yes, thank you, ma'am. Thanks for this. That's a wonderful question. The initial stage of the panel itself. Yes, definitely they have included the handcuffing in the new, but not for the less serious offences, but for the serious offences they have included, but which is definitely violating the fundamental rights of the person. And yes, according to the, when it comes to this particular aspect, according to the Article 21 of the Indian Constitution, is very clear. Unless the procedure established by law. But this particular aspect, the procedure established by law, is curtailing the rights of the person. In fact, many citizens, the provisions which they have enacted.
This is Vinayaka. So you spoke about timeline 30 to 45 days. So what do you think about the people who are already being not brought up to the trial? They're still in the prison without knowing what exactly where they are. So what do you think of them?
The timeline of the 30 to 45 days would be for the judgment to be given. Now, what will happen in trials which are pending under the CRPC is that they're going to be kept pending because the CBI code will stay the same. Now, they'll have to take on trials after July 1st as per the BNSS Act, and they will have pendency of trials under the CRPC pre-July 1st. So my point is only that now judges are not going to be inclined to go into trials in the CRPC because There's no specific time limit there for completion of trials. Although Section 309 says that you have to do the trial on a day-to-day basis and you must endeavor to complete it quickly, it doesn't have such a stringent timeline as the VNSS does. So in terms of pendency, it's going to be huge. And in terms of judgment, I don't think they'll be able to deliver it in 30 to 45 days. There's going to be no time. They're going to have to sit the whole day to do trials. Because there's not going to be 2, 3 CBI codes. There's still going to be only one CBI code doing the circumstances.
I stand with the point of Ramya. And yes, adding to the point of Ramya, like when it comes to the delay in justice, is one of the most important, to eradicate the delay in justice is the common objective of this particular VMLS. But when it comes to the implementation, I don't think it is. When it comes to enforcement, I don't think it is possible because there is a huge number of cases pending in India as well as when it comes to the trial, conducting the trial, it is not that easy to complete. For example, when it comes to the framing of charges, within the 60 days they have to frame the charges. Once after finding the charges, once after framing the charges, they have to do the argument. Within the 30 days of completion of argument, they have to complete the trial, which is give the judgments. So all these kind of lacunas are there in VMLS, and most importantly, if you're saying that denied justice is denied justice, obviously the hurried justice is a buried justice. So definitely we cannot encourage all those kind of time limits, since the law itself included the rights of the every citizen.
Just to add to that as well, there have been a lot of judgments of the Supreme Court in which they refuse to in fact fix timelines for trial under the CRP. PC saying that unless there are circumstances that really push us to do this, we don't want to go ahead and do this. We don't want to fix time limits for trial. It simply takes away the rights because the witnesses may not be available on certain dates. I mean, they do have other work to do. They're not entirely sitting in court. More importantly, the PPs who come, they may even have to go to the High Court for a matter. How are they going to, come every day without taking an adjournment, sit here and conduct a trial without a break? That may not be possible. To recall witnesses now may not be possible. So, like you said, it's going to be the opposite of what they intended.
So in that case, the VMSS also speaks about technology. So not we use the technology in 30 to 40 days or...
Yes, but you can't clone the person. I mean, they're still going to have to attend it. They're still going to have to come, sit in that place. And if it's going to be a trial where, the people who are in the marginalized sections of the society, how are they going to have access to the internet? With what laptop are they going to do this? And most of the courts now, they already have remand hearings. In most of the cases that I go for are all video conference remand hearings. But what happens is that even in the white collar courts, you will be able to see the video, but you won't be able to hear it. So what ends up happening is the judge then calls them physically for the remand after lunch, where they come all the way from Pune. So all of these already exist. But how are you going to reach it to the person? How are you going to reach it to the witness?
You want to add something?
Regarding this, once after get the assent from the president, they're upgrading the police station with necessary IT professionals. Now they are updating every police station with the necessary IT professionals, and they are recruiting the more IT professionals in the police station, and they have been trained by the professionals. And now for that purpose, they are appointing a nodal officers in every police station, and they are going to take in charge, and they are going to have a separate email ID for that police station, and they are going to have a separate email IDs for the police officers, and it will be available in the public domain, and the people will get access to that public domain, and they can get access to the mail IDs, and if they want to file FIR, EFIR, which is electronic communication FIR, they can file the FIR, and within the 3 days of the filing of the FIR, they can go for the investigation. So in that case, it has a provision. But I don't know how far it is going to work when it comes to the enforcement, and how far it is practicable to follow. So that is what the issue is.
This is very interesting that you point that out. Actually, this use of technology could have also been used to sort of decongest prisons. What you could have then done is you could have given ankle bracelets as it exists in the US. There are going to be so many IT professionals and nodal officers sitting. Then in non-violent offences or even white-collar crimes, at least for under trials, they could have said you don't have to be in judicial custody at the central prison. You can be in judicial custody within certain perimeters that I put, say for instance your home, or you can go from your home to your office. And since there's going to be so much advancement in technology, it's going to be quite easy for them to track. They can have GPS. So they could have also dealt with this issue of congested prisons, with this issue of 76% of inmates being under trials using this technology. Since they're anyway spending a large amount of money on this infrastructure, this could have also been done. Maybe in the...
Okay, I would like 2 questions from the audience so that we could again have a discussion. Yes. Can we have some mic to somebody?
So, good afternoon, panel. So, I have a small question to address in this panel. So, is there any, provisions that enhance the victim's rights? So, compared to the CRPC that have been included in this VMLS?
I think there are, I'm not sure about the specific provisions, but enhancing, I'm not sure of, because victim compensation, etc., was already part of the CRPC. It was slightly more discretionary, I would say, earlier. You could apply to the judge and then they would decide whether there's compensation. It's more codified now, as has been done with most of the changes. There's a lot of codification in terms of victim compensation. I would say that is one of the greater rights. And now they say, oh, you have to give a copy of the investigation police report and all the materials to the victim as well. And they put a time limit on it, 15 days or so. And similarly, the police are mandated to inform the victim or the complainant, so to speak, of the progress of the investigation and what is the progress of the preliminary investigation on the FIR. So to that extent, all of this has been quite well codified. That would be the only enlargement in the rights of the victim.
So, looking upon to the police custody, so in VNSS, is actually stated that 90 days have been, 60 days have been extended. So compared to the CRPC, in CRPC the police custody is 15 days. So the extension of the day, police custody. So how we are looking on it, ma'am?
You're asking about the extension of 40 or 60 days when it comes to the police custody. So when you come across with the CRPC, it is extended 15 days, which is like when it comes to the BNSS, they have extended as a 40 or 60 days, which can be like we can use particular 15 days within that 60 days. Whenever there is a need of inquiry, whenever there is a need of investigation, like they have to know further about that particular occurrence, they can go for that. And they can, with the permission of the judicial magistrate or magistrate, they can call the accused and they can do the inquiry within that 16 days, not after 16 days, but within that initial 16 days of the investigation, they can go with that. And like when it comes to that, it can negate the bail also. Like, when it comes to that, actually, the compulsory appearance or compulsory custody of the accused person is not necessary in many cases. Like Supreme Court has decided many cases in that. But when it comes to the BNSS, it is very clear for the purpose of securing more evidences and for the purpose of being more clear about the occurrences. Police have more power in the BNSS and they can take a person in custody, in the custody, and for the purpose of the investigation within the initial days of 60 days.
But it will create some threat to the accused person, so alleged person.
Yeah, that is a possibility. But thing is, when it comes to this particular aspect, only with the permission of the judicial magistrate and only with the permission of the deputy superintendent of police, according to the permission, they can take the person into custody for the purpose of investigation. So the provision runs accordingly, and provision is very much clear that not violating the rights of the accused person, the provision has to be used. The provision is very clear.
Yes, can we have one question from you?
So,
Good afternoon to both panelists. My name is Soumya and I teach criminal procedure and evidence at VMLS. So I have one major question, or probably I would like to expect one of your remarks on this. I personally believe that the new code of CRPC, which is BNS, is a lost opportunity in the sense that there has been no law which has been made with regards to electronic devices or any search of those. And when, with regards to the impact of technology that both the panelists were discussing, don't you think the government should have made some clear provisions? Because there is a public interest litigation pending before the Honorable Supreme Court with regards to guidelines for searching any form of electronic devices. Now, as far as the recent developments are concerned, there are 2 to 3 high-profile cases wherein questions with regards to how electronic searches various devices might be conducted. So, what are your remarks on this? And do you think there is any productive aspect which could have been brought in? And also with regards to my understanding with regards to Mr. Gauri Shankar. So, you had made a remark with regards to Article 348 where it mentioned that the Parliament has to make all laws in English, which is correct. But then after, maybe it's my interpretation, it mentions that the authoritative text shall be English and there is nothing which is mentioned about the cause title. So I think that is my remark. So in case if you would like to clarify your interpretation of the same. So thank you.
In terms of seizures of devices, I think there's always a split sort of opinion on that. Now, looks like from the law, you can seize the mobile phones. You can seize practically anything you want. Especially, you can forget about seizing mobile phones and laptops. They said you can ask anybody who you are quote unquote investigating to give voice samples and fingerprints. So, given that that in itself won't be self-incrimination, it's very unlikely that this is going to be stopped. I think that is a pretty much decided thing now. Given the new law and the way in which it goes, you can practically seize anything. So I don't think they would have needed to clarify this beyond that as well.
Regarding the second question, yes, I completely accept with your question. But the thing is, when it comes to the term Sanhita, the meaning is very clear. It is a law, but that is the term called code. What is the purpose of having a Sanhita instead of the term code? So that is what my question is. Like mere writing the term in English, it doesn't mean that it is English. So Sanhita is not English. It is something different from English. So we cannot call it as English since it is written in English letters. So what is my interpretation is the code is the exact term which we are using so far. So why there is a change in that particular term? That is what my question. That is what my interpretation, and thanks for that question.
Sir, kindly explain the suspension of sentence about the new CRPC, as well as the default debate that is called the mandatory debate. Old Act is concerned, section 167 class 2A1 is there. What about the new Act? What about the 389 1 and 2 of the old CRPC compared to new BNS? Please explain, sir, and the default debate and the suspension of sentence.
In respect of default date, I think the provisions now say that if you're a first-time offender, they said within the 1/3 period of your total sentence, that is your highest sentence that is there, you can be released. However, what it has also done, as I also explained in my introductory remarks, is that if you're charged under, say, 2 different acts, and this could be anything, it could be charged under the company, that could be charged under IPC, which could be charged under PMLA, which is typically what is done because there's a special act for everything now. Once that happens, then you are not entitled to default bail as you were under the old act. Under the old act, if you served half of your sentence, then you would be entitled to a default bail, irrespective of what you committed. It could be an economic offense, it could be any other offense. However, now that is not going to be possible. So typically, you're going to have to stay in till the conclusion of your trial, and default bail is basically become a no-go now for anybody who's charged under 2 or more acts. So for very simple crimes, I guess that is the intention of the legislature. For very simple crimes, now your default bail period is reduced. You can be out in 1/3 of the time. However, if you're a repeat offender, or if you've been charged under two different acts, then your default bail is basically an opportunity.
Yes, what is your next question?
Hello, ma'am.
One second, can you just hand over the mic to him because he was asking his second question. Sir, another question for the repeat.
My question is, suppose Indian Penal Code read with the VMLA Act, you cannot easily come with the VMLA Act way. That is so many cases is there. I ask question only for suppose two offenses, two sections registered under the Indian Penal Code. What is the old act is concerned 167(2)(a)(1), 167(2)(a)(2) CRPC is there. That is above the above 10 years offense 90 days. Below 10 years is concerned 60 days. What is the
See, even if it is the PMLA, the default bail provisions relate back only to your CRPC. They are not any different. Your bail provisions are different. Your default bail provisions come back to the same. So there is no change. The answer remains the same. Yes. Now, if you're only a first time offender under the CRPC, say you've been charged under 3-4 sections, say forgery, cheating, etc., you can come out in 1/3 of the time if this is your first offense. But if you've been charged under IPC plus some other law, as what I understand is multiple charges would be, then you are.
What about the suspension of sentence? 389(1) old act is concerned. 30 days, the same court can be 3 years below sentence. The same court can be suspended the sentence. And above 3 years, the appellate court alone can suspend the sentence. If the offense is bailable one, the same court is suspended the sentence. Example, old act is concerned section 494, maximum of 7 years imprisonment. And the offense is bailable one. The same court is granted suspension of sentence. What about the new act?
I'll have to see. I'm not sure.
Thank you, ma'am.
And another question, you have asked about another question regarding the two offences, default. When it comes to punishment, it run concurrently. For example, if it is going to, if a judicial magistrate is taking over the case and if he is going for the trial, for example, if one offence is 3 years of imprisonment and other offence is 2 years of imprisonment, he can go for the punishment for that particular offence runs concurrently, consequently. For example, but when it comes to the imposing the punishment by the judicial magistrate, he cannot impose the punishment twice his jurisdiction. For example, if he can give up to 3 years of imprisonment, he cannot give more than 6 years of imprisonment. Only the 6 years of imprisonment he can impose according to the new legislation. So it runs concurrently. Thank you.
Okay, I have a question. When we speak about zero FIR, the current DMS case, I hope we had seen in Nirbaya's case, Justice Verma Commission. How do you think that this zero FIR will give us a positive note in this current BMSS?
Thanks for the question. Actually, when it comes to the changes in BMSS, it runs through like many years, before many, like right from the 2004, they are asking for the new implementations in the criminal justice administration in India. When it comes to this particular aspect of zero FIR, like after the Nirvaya case, like Justice Verma committee recommended the zero FIR, as my court understood, like there was a provision for the there was a zero FIR in the CRPC, but now they have implemented exactly in the 173 of the BNSS, and zero FIR is like you can file the case in any jurisdiction. Like when it comes to the when we have come across with the panel, the panel this morning. So they were very much clear about the practical issues in a filing FIR. For example, when the client or when the accused or when the victim is approaching the police station may deny to file the FIR since they will not consider the purview of that particular jurisdiction. But introducing the zero FIR in the BNSS, it is like going to be a tool because they are going to file the FIR irrespective of the jurisdiction, and they are going to forward the FIR to their particular jurisdiction once after the inquiry. So zero FIR is something which is appreciable to my knowledge. Yes.
But as Ramya pointed, Tamil Nadu already has this zero FIR concept where any jurisdiction, anywhere, not particularly that you have to go to that particular jurisdiction, then you have to give a comment. So anywhere the incident has happened, you can just go to the station and give. Don't you think? Okay, this is in Tamil Nadu. I'm speaking about over the India.
Yes.
Pan India. So what changes it will have after VMLS? So already we have one already. So what is?
Yes, the thing is like when there is a strict enforcement of all these provisions, definitely that will be a change. But when it comes to the 173, the clause 3 speaks about the preliminary inquiry. So when it comes to the inquiry and then filing FIR, it's a preliminary inquiry. But when it comes to the zero FIR, they will go for the petitions for like the complaint without any jurisdiction, without knowing the jurisdiction. For example, like as Ramya said, like this is very clear. The jurisdiction plays a very vital role in a CRPC, which is like a VMSS. So taking up a complaint by the police station according to the jurisdiction is definitely cannot be encourageable. So in this particular aspect, like zero FIR is one of the most essential thing which has to be incorporated in the VLS, and they have incorporated. CRPC never like included the zero FIR. So this particular VNSS is enforced the zero FIR. So that is the thing. Like when there is a rules which is compulsory, mandatory to be followed, definitely the police station has to be followed. The police has to be followed. The enforcement authority has to be followed. So VNS is very much clear about it. It enforced mandatory zero FIRs.
Okay, we will take a question from our audience.
My question is during my internship period. Hello. During my internship period in DLSA, the judge who works there said that like there are many put-up cases on innocence, and I have even seen those things. Now my question is, like in the new procedural code, it is said there are certain time limit is given. So according to the time limit, the court has more power now to they can make more big cases, right, on innocence.
So, I mean, if I understood correctly, what you're asking is that you're saying that there's been unbridled powers given to the police and therefore they can register anything. I mean, they could always do that because typically FIR was in their control.
Now there's a certain time limit that's given, like you must file an FIR.
Yes, I think. When it comes to the FIR, like for example, if you're taking an offense which is more than 3 years of imprisonment, less than 7 years of imprisonment, they have to go for the preliminary inquiry.
Which was already actually there. You have to conduct before doing an FIR. Now, in fact, it's been watered down to say only
14
for
days.
offences.
Yeah.
14 days, and also only for offences more than 3 and less than 7 is oddly only for that provision. Whereas before it existed for all, you had to do a preliminary inquiry before you go well.
Yes, exactly. But the thing is like what he was supposed to ask is like when it is that is a time limit for 14 days. Definitely there will be a chance of making a case. That is what.
Yeah, don't you think the police can make a case on it?
Yeah, certainly. I mean, the point of preliminary inquiry would also be to work both ways, because first they have to collect certain evidences and they'll have to say, this is the report of my preliminary inquiry. I'm sure there's a report that they'll have to give it to their superior. And therefore, if they want to, they can concord anything, depends on what the complainant gives. So I don't think it makes it one way or another more dangerous for the police to concord a case. Either which way, they'll have to go through the evidences, which they're already doing, to make a preliminary report.
Can we have a next question?
One, just I'm conscious that I've been expanded this and I don't want to shoot to them, but I'm just trying to add on to what you just said. See, the concept of registering an FIR is already available. The FIR has to be registered. Once a cognizable offense is made out, the FIR has to be registered without any delay at all. this question has been clarified by the Supreme Court in Lalitu Kumari's case, wherein they said that if a cognizable offence is made out, FIR has to be registered immediately and without immediately. Thereafter, after taking the 167 statements and all other relevant evidences that are required for the activity establishing the case, in the event that the police find that after a review investigation that no offence is made out, they can always file an negative charge. That nothing empowers the police to refrain from filing an FIR. FIR has to be filed the moment a complaint is received. Only the question of continuing with the investigation and filing a charge sheet to rest upon the police, and that will depend on the evidence.
Yes.
So the new act does not change anything with regard to that.
Yes. Also, now it says that once you receive, so like you said, once a cognizable case is made out in the minds of the police, they must register an FIR. They do not have any discretion there. However, now it has been clarified one step earlier. If I come and give a police officer some information about, say, an offence which may or may not be cognizable, and if the police officer is not able to make out whether at time of facie it makes out a cognizable offence, he can then conduct a preliminary investigation. Now, what's going to happen is, interestingly, with the zero FIR being codified, what is a police officer who's situated in Tamil Nadu going to do if it pertains to an offence relating to Bangalore? How quickly is he going to be able to pass it on? Because a preliminary inquiry that has to be done. If he's not certain whether it's a cognizable offence or not, how is he going to conduct that inquiry if it relates to an information in Bangalore? These are things that will remain to be seen. You can't codify everything, so I guess it'll have to happen with the judgments that are coming.
So the terms like without delay now has a certain time limits.
Hello, this is Prakash Swami for senior journalist. You don't know the difference, any difference between the old law and the new law case I mentioned. In a criminal case, the charge sheet has been filed in the court of law, typically a magistrate court. The police filed the charge sheet, and prima facie evidence has been made up. And subsequently, if the victim proves that it's fake, it's a false case, and the judge convinced that it's absolutely false case, they are not accepting the discharge petition. They are insisting on a trial. Trial could take 3 years, 30 years, 20 years. But the judge says, sir, I know that we can't accept discharge petition because we set a long precedence. So is there any law in a new provision, even if we file a charge sheet, and if the magistrate or the competent authority comes to know that that charge sheet is fake, 90% of the police charge sheets are fake. We all know that. 90% of the FIRs also fake. But what is the role of the magistrate in the new law to protect the victim's rights, or they have to go through a trial 30 years, 20 years, and get themselves relieved? The second question is, no CSR FIR. Somebody was saying, in 9 out of 10 cases, they are not filing CSR FIR. A lot of my friends have to go to court, get a court order to file FIR, and they are not respecting the court order. Bharatiya Kumari case is a classic example, quoted again and again, again and again, again and again. But the law enforcement officers have a scant respect for judiciary. They said, we don't care. You go to court, you file a contempt, I want to appeal in the court. Now, there is a dispute between the law enforcement and the judiciary, because we all need a complete revamp of the judicial system and the police system, which is not happening. But at least in a short time, is there any remedy in the new law? But when we find out that the charge sheet is fake. Thank you very much.
So, like you said for the first question, most people are slow to give you a discharge. The magistrates or the police station, they're all very close to, they're very scared to say discharge the accused, because they feel, no, you've already come this far and all of this has been there and no charge is made against you in the charge sheet. They say, no, you've come to this position. Under the old law, like you said, you would languish in trial for years and years and years. I guess the only change that has been brought about in this new law is you won't languish in trial for years. It may be a couple of months or days before which you have to finish trial and give judgment. Therefore, one way or another, you have some sort of a conclusion to that. So, you filing discharge now, magistrates may be more and more reluctant to grant a discharge, because they say, why don't you just wait? Trial is anyway going to be concluded in a couple of months. It's not like earlier. Therefore, now discharges, even quashes in the High Court, will become very difficult because the High Court judge is going to say, I have to take whatever is there in the FIR as gospel truths. I cannot go beyond that. So they're going to say preliminary inquiry has already been conducted by the police. The police has then put that in the form of an FIR. Therefore, I cannot quash the matter. Similarly, a magistrate is going to say, why do you want a discharge now? You come this far, participate in the trial and wait for the verdict. That is what is going to happen. In terms of that, you won't languish for years. But it has not dealt with any of this. Also difficult to codify because these are primarily discretionary remedies that are given to the court. Therefore, it's very difficult for you to codify and say A, B, C, D circumstances you must discharge, etc. The law already exists in the Supreme Court, and like you said, it is hardly being used, mostly by the magistrates. It's going to be difficult. And with respect to the registration of FIR problem, yeah, in terms of tendency, even now if you see the cost list in courts, most of the matters are going to be registered FIR. And a similar order is being passed by the court because they don't have that much time. They have about 400 matters listed per day. About 150 is going to be read for registering FIR. And the uniform direction is going to be given depending on the judge saying, okay, to register FIR within so and so. It is also very difficult for the police to go ahead and then investigate and register FIR in all of these matters, which is why it may be sometimes seen as a scant disregard to what the judiciary has said. It may be very difficult for them to do it because the court has given a direction saying register FIR, but a cognizable case must be made out there. Once the police investigate, they may find out that that is not the case. So that tendency has also not been addressed. It's going to go on. Now they say you have to register FIR, like he said, it was always the case. So no great change there.
There is very perjury law in India because people file false cases. After 2 years, there's no punishment to.
Ideally,
the perjury law is must in India.
No, ideally the state must award compensation for those who have wrongfully gone through trial, which was already there earlier. But I remember reading about this one case. I don't exactly remember the title. It was a case of sexual harassment, and this man was in jail for a long time. He lost everything. He lost his job. He lost his family. And finally in trial, I think this was in Delhi, finally in trial he was proved to be innocent. And he then applied to the courts saying, I now want compensation from the complainant and the state. It was a very clear case in which he was held to be innocent and there was video recording showing that her case was false. The court refused to grant compensation. Very, very difficult to get compensation out of this.
Thank you for the question. I'm Gautam from Tamil Nadu, Dr. Law University, School of Excellence Law. Here I am going to disseminate 2 questions. Number 1 question is, we have the general law as well as the special law. The special law will prevail in comparison with the general law. Now the new 3 criminal laws came, the NSA and the NSS. Like this. When we come to this priority, what we give the most priority to the general law or specific law. Since the general law came earlier, the specific law also there. The second question that I am disseminating here, the criminal rules of practice. What will be the validity of the criminal rules of practice which was enacted in according to the manner which was known to the law and according to the code of criminal procedure.
A general law will always remain the general law, irrespective of when it is enacted or not. So, if you have a general law like the IPC listing out the general offences, and then you have a specific law for certain kinds of offences, you will always be tried under the special law, except in some cases where it could be both provisions could go hand in hand and you would charge them under both provisions. So, there's no question of one prevailing over the other simply because the IPC has now been enacted as a new law. It will both go hand in hand, and a special law with respect to certain offences like say economic offences would always remain the special law under which you are going to be prosecuted. Again, even special laws like the PMLA and the Companies Act, they rest on the shoulders of procedural aspects of CRPC, etc., for default bail, for conduct of trials, for inquiry, investigation, etc. That is still going to remain. So it will both go hand in hand.
And when it comes to the special law, like VMLS itself have a provision states that when there is a general law as well as a special law, the special law will provide owes the VMLS. And it is very clear in the provision itself. And what is the second?
Criminal rules of practice.
Criminal rules of practice. What will be violative of the criminal rules of practice? So you are asking whether it will be a violative of criminal rules of practice. Criminal rules of practice was enacted.
Criminal rules of practice which was enacted according to the Code of Criminal Procedure in High Court throughout its territory in Tamil Nadu. These are the rules which was made by the High Court for practicing criminal rules or advocates.
Yes, subsequently it will change. Like since we are adapting the VMLS, definitely there will be a change.
We have one question in the front and next we go to.
Hi, my name is Nishant. I'm a faculty of law at Vinayaka Mission's Law School. So my question pertains to the overall objective of the newer laws. Right? If you consider the code, for example, every saint has a past and every sinner has a future, right? And if we connect it to CRPC and its objective, the overarching objective of CRPC is not just to punish or to provide procedure, but also to reclaim the citizens back and give them a future, right? So if that be the ethos of the newer laws, do you think the newer laws are in a way providing for that infrastructure for the sinners, if I call them, to be back in the society and to be shaped as citizens?
That's a very interesting question, Yas, and in fact, we were just discussing that over lunch. To say what is the rationale behind certain kinds of punishment, what is the rationale behind keeping people in jail as under trials for longer periods of time. And this is a serious lacuna in the new law because it does not address this. In fact, it seeks to put more people in prison without convicting them of the offense as under trials for longer periods of time. And it doesn't have anything on the rehabilitation part of it. So imagine a situation where a white collar criminal is in the same prison as somebody who's committed a rape or a petty offense. And you're an under trial white collar who's there. How are you going to come out of prison? How are you going to be? Because what you're seeing, the society that you're used to, the kind of people you're used to speaking, and the prisons that you're in, sometimes you may even be in B-class prisons. What is going to happen to them? None of this has unfortunately been addressed. So I don't think there's any question of rehabilitation that has at all been discussed in the new law, or infrastructures for the same.
Hi, good afternoon. I'm Amrita. I'm a faculty at VMLS. I'm seeking sort of an opinion or your thoughts on, it's neither on the procedural or substantive part of all the three laws on the criminal laws that have come, because the discussions over them are only going to intensify in the time to come. What are your opinions on the amendment that has come to, that increases the scope of the document, like it increases what kind of documents are admissible, and also with regard to admissibility of electronic evidence, what implication of them would be on the right to privacy of an accused? Do you think they would have any sort of implication, or it would be same, or anything would change? Thank you.
When it comes to this particular questions, we have read along with the criminal amendment which made in the year of 2022, the Criminal Identification Act, and which we have, the VNSs have been incorporated also kind of thing according to the section 176 clause 3. And the thing is like, yes, that is a huge threat for privacy if you are reading in a bird eye view, but when we are having an interpretation over the provisions, definitely I say that there are checks and balances in the provisions. So when it comes to that particular thing, like as we have discussed earlier, we have been come across with many such kind of investigations with the forensic expert, help of the forensic experts. For example, when it comes to this particular aspect of 173 of the CRPC, when you are taking a cognizance of offense, like filing an FIR, it is necessary to go and visit the scene of occurrence, place of occurrence with the experts forensic experts, and they have to collect the forensic evidences from that particular premises, and they have to they have to hand over that particular report to the IO, investigation officer, within a certain time period. And when it comes to the huge change in the BSS is like taking off the forensic sample, like samples, biosamples of the rape victim, and they have to do the forensic. The experts have to submit the report within a certain days of filing of an affair. So in that aspect, definitely like it is going to be good in one aspect, but as we have discussed in the whole discretionary power of the police, how we are going to utilize, and when it comes to the securing all kind of electronic devices and safeguarding the all kind of biosamples, whether India has such kind of infrastructure to safeguard all such kind of biosamples. For example, taking up of bodily fluids of the person and taking up of the fingerprints or any other like biosamples. Whether India is equipped with all such kind of device, or whether India is equipped with all such kind of infrastructure to safeguard the biosamples. That is what the case is all about. Like because we are the country which we missed files for in many cases, which includes a close and close of amount. But when it comes to the biosamples, whether our police station, like in that particular aspect, like the Act, Identification Act is saying that police officer in charge in a station, like any police official who is and comes under the copy of the officer, they can compel the person to give a biosample when it comes to the getting a biosample from the person. So that's no need of a preliminary inquiry or anything. Once they are finding the cognizable offense, they have to give the biosamples. So this is what the stringent rule which is prescribed in the Identification Act as well as in VMLS. So which is going to be a threat to the society, as you said, like there will be there is a possibility of violation of privacy in that aspect also. Yes.
Greetings to the panelists. This is Ashwin Neelakandan from Chennai School of Law. And my question will be, with respect to search and seizure of products, is there any possibility to implant an evidence against the accused present by the police?
This is already being done and that is going to go on. Of course, you can implant anything now. In terms of electronic devices, it may become a little more difficult because you better know whether that was mobile phone or laptop, etc. So in my opinion, it may actually reduce. So, and if you're going to collect voice samples, etc., really good technology now, you're going to be able to figure out. So to implant evidence may actually be more difficult. If you're talking about a typical implanting of a knife or a weapon, murder weapon, then yes, that has already been done. Always been done as a practice.
This is to Gauri. You spoke about biosamples. So how far it's going to be like safe. So we in India even we lose our Aadhaar details just for 5 rupees. So I don't think the biosample will also even we can get paid for 2 rupees. Okay. So the BNS also speak about transparency and accountability. So how do you think the high profile cases like Inaugural or Satyam cases, so how do you think it will validate on this? Maybe like procedure wise or evidence wise?
Yes, thanks for the question. Actually, like when it comes to this particular aspect, like, the transparency is one of the most essential objectives of the BNS. But whether they have enacted the law, whether they are going to enforce it or not, that is what the question is. Like, yes, as you said, like there are high-profile cases which we have found, and there is a possibility of misleading the provisions. And I think the BNSS have, as a provision, BNSS have a lot of checks and balances, like appointment of various officers and hierarchy, and they have to be transparent to one another. And as my co-panel said, there is a time limit and time frame for everything. So, and they have to pass investigation report to the victims, and they have to pass investigation report to the accused person, and they have to pass an investigation report to the magistrate in a equal time frame. So, I think that is checks and balances, and I think there would be a transparency by way of including all these kind of time limits. But how we are going to enforce it is the every question again from my side.
Question for Ramya Subramanian. Madam, the three new acts, whether they increase the cases or reduce the cases, what do you feel about the three new acts?
I mean, definitely it's going to lead an increase in cases because more and more, there have been a lot more offences that have been introduced which are new. And also, given that the trials are going to conclude quickly and bails are going to be more difficult, there are going to be more and more people filing cases because they're going to say, okay, go through the process of trial, and it's a win or lose situation for them. So you see a lot more people filing cases, and there's going to be a huge tendency of cases. There's going to be a huge number of criminal cases that are going to be filed because most of the quote unquote victims, they know that now it's going to be very difficult for you to get bails or even statutory bails. So that is a win-win situation for them, especially in false cases. Like as he was saying, there are going to be a lot more false cases, there are going to be a lot more cases that are filed.
And it's a check and balance of the investigation agency. Is there any provisions?
Is there any provisions of check and balance of the investigation agency?
In terms of investigation, I think now the fact that you can go ahead and you have to record the entire investigation. When you, for instance, a search and seizure by some of the departments, you're going to have to record it. So in that sense, that would be the only checks and balances I would say is there. Apart from which the preliminary inquiry report which has to be prepared. I would presume that is based on certain material and the court can always call in for it, saying what was the preliminary investigation that led you to this. So these are the only checks and balances. Apart from that, there is nothing new that has been introduced. In fact, more powers have been given.
Any more questions? Yes.
My question is with regard to witness protection scheme. So now we have a scheme thanks to Supreme Court judgment, got from 2018. Now which gives not a very loud way, but it's a witness protection scheme. But now VMLS says that the state governments have to come up with witness protection scheme of their own, which means that there is going to be a difference scheme for different states. It won't be a common witness protection scheme which will be applicable to country, the country, right? So which is going to be it also differs from the witness protection scheme which was made into a law by the Supreme Court of India. But then the problem here is that if had it been the witness protection scheme by a central government and there had been different state witness protection scheme, and if there's a difference, the central law will prevail. But in this instance, we have a Supreme Court judgment which makes a witness protection scheme into a law, and then we'll have state witness protection scheme. So what happens when there's a different, when there's a difference between that scheme and the state witness protection scheme? So I'm not sure whether on that, I'm not sure whether the Parliament has thought on when the state is going to make a witness protection scheme, how it could create trouble in terms of enforcing that scheme throughout the country.
They'll have to follow the guidelines that have been laid down by the Supreme Court. It will be as simple as that. Because then it again goes up for challenge. This will be the law that prevails as the law of the land. Therefore, every state will have to go with the guidelines. There may be minor changes, but more so they have to adhere to this.
Adding to that, like VNS has introduced many provisions. They have incorporated many provisions for the purpose of upholding the rights of the witness. For example, when it comes to the person, one who is more than 60 years of age, or if the person is infirm and the person is ill, you cannot force the person to be a witness in a case if the case is in another place. Right? There is a general provision which upholds the rights of the witnesses, and according to the section 398 of VMLS, it is very clear that is a witness protection scheme, and as panel said, like we have to go on to the guidelines if there is any kind of conflict. If Like that is a state with the scheme corrections, or is that the central scheme corrections? Like we have to go on to like as per the regulations.
Anybody would like to add on any questions? Or if you like to give your suggestions also, it is more welcome. I think our VMLS students also had more questions today. Sorry.
I just have a question. So, the new law introduces trial in the absence of the accused. So, what would be the impact of the defense of the accused if it is going to happen in their absence? Or what is your take on this concept of conducting a trial in absence of the accused?
This is mainly for accused who are absconding, and sufficient opportunity is going to be granted to them to come and appear so that they don't evade the process of law. If they still absconding, then too bad. It is like a judgment which is going to be passed ex parte. Now, how you're going to execute that judgment again becomes a question. Because if you're not even able to secure an accused for the purpose of trial who's absconding with your rights of arrest, etc., how are you going to ensure that the punishment is implemented? You may be in a state which is not a contracting state. You may be in a country like Dubai where they're not going to let them go so easily. So you may conduct a trial, very well finish it and do a lot of punishment. However, how are you going to ensure that is executed? That becomes a question. Otherwise, I think it's a good rule.
And then what about the trial part? And when it comes to the offender, like VNS is very clear about the proclaimed offender. They have defined the term proclaimed offenders, and when it comes to that, more than 10 years of imprisonment. The offences which is committed by a person, more than 10 years of imprisonment, has to be deemed as a proclaimed offender. Earlier it was not that. And so, as per the regulations and the rules which is prescribed in the VNSs, and the trial has to be considered, and he has to be considered as a proclaimed offender. And that is the certain regulations how we have to deal with the proclaimed offender according to the particular section 84 clause 4 of the VMLS.
Okay. So how do you think the technology will prevent from stealing the informations in the current VMSs? Informations.
So regarding the stealing the informations, and it is already there, like since you itself, like the moderator you itself, like told that stealing the informations are the, and for 5 rupees, like we can give up on our privacy. And definitely there is a possibility. Definitely like a coin, we have both progressive as well as regressive things in an act. And yes, that is a possibility of stealing of information. But BNSS will definitely definitely not give a room for that. But enforcement authorities like police officials have all these kind of provisions where they have to protect their information from the people. So yes, that is a issue with that, and even I am going there like we can't assure the information will be safe. Yes.
I have a question relating to witness protection because now we have dealt with the tampering of witness in all the cases. So how we are seeing that, and now what are the rules for that?
Yeah. As we discussed earlier, like section 13988 provides the witness scheme, whereas in a separate manner, like we have other provisions which upholds the rights of the witnesses. And definitely that's a possibility for tampering of evidences and tampering of witnesses, which is already there in the Indian Evidence Act, and we can go with that. The same provisions is incorporated in the BSA also, Bharatiya Sakshya. So definitely we have to follow the guidances or provisions in that particular aspect.
Any more questions?
Good afternoon. I'm Kritika from a student of Vinayaka Mission Law School. I had a question that What improvements does the new CRPC make in protecting the rights of individuals under arrest?
And the most important thing when it comes to the arrest is they have incorporated the sector 40 and 41 in the old CRPC. They have jointly we are dealing with 35. Now, one of the most important aspect of rights of the arrested person is earlier you can inform the parents, relatives, or friends, but now the accused person, which is the arrested person, have the right to choose a person to whom he has to be addressed. For example, if he want to convey the arrest about this arrest to a person, he can suggest according to the provisions of VMLS, and more particularly, not throughout the interrogation, but definitely he can go for the assistance of the advocate according to the VMLS, not throughout the interrogation, but definitely he can ask for seek help from his own advocate, and he can have a right to choose his advocate in the time of the interrogation itself, and he can choose the person to whom he has to address about this arrest. So VMLS is very much clear about the rights of the arrested person in that person.
Any more questions? Or we can go for a conclusion remarks. Okay, as from our both panelists, we could see that DNSS is still a debatable one. It's just a legal document, or you could say it's just a blueprint. So once after July 1st, we will come to know like how far it is access to public and how far the technology or how far it is streamlined, transparency and accountability, or it is victim-centric. So I would like to ask Ramya and Gauri to share their closing statement on this.
I think there is a lot to be amended in this law, and that can only happen with the practice of the procedure itself in courts. Because most of the times the lacunae and the loopholes you only find out while it's being put into practice. It's too early to say, like you said. We'll have to wait and see how it goes, and accordingly we'll have to amend the law. Because there are a lot of judgments which have earlier given, for instance, the Gautam Nagarika judgment had given a very good recommendation in the judgment, saying why doesn't the parliament look into having provisions for house arrest in the CRPC? That has been left out. Now all of these things can only be amended later on as the law starts to function, and we'll have to wait.
Enactment wise, the VMLS is going to be a huge, maybe to create a huge impact in the country, but definitely when it comes to the enforcement, I don't think it will, because it has many provisions which is exactly like the CRPC. It has very few modifications in provisions here and there, and a few positive sides, which is like general legal provisions, and it talks about the rights of the victim. In certain provisions, it talks about the rights of the accused person, and in certain other provisions, talks about the rights of the witnesses, and it upholds the rights of the witnesses. But in a paper, it is very much stringent, and it is very good to read or to understand. But when it comes to the interpretation or when it comes to the implementation, we have to wait and see, as my co-founder said. And yes, we have to wait for the enforcement, and we have to wait for how it is going to be implemented effectively and how it is going to be.
Thank you.
Thank you all. That was a very engaging session. Thank you audience for actively participating, and thank you panelists for taking a lot of questions from us. Thank you very much. I now request Ms. Sandhya, Associate at Surana, to felicitate Ms. Ramya Subramaniam. Thank you. I request Mr. Kannan, Associate Surana, to felicitate Dr. C. Paulina. Bhavisha. Thank you, panelists. I request the audience to pause for a few minutes until we set up the stage for the next session. I request the guests to please take the seats forward on the front. We'll be starting the next session in another 5 minutes. Start the next session. I request the audience to please take the seats at the front. Could you please move forward? I request the guests to please take your seats. We'll be starting the session now. Moving to the last session of today on evidentiary justice. This session will be moderated by Professor Nishant Shekhar, Associate Dean and Associate Professor at Vinayaka Mission Law School. He is an award-winning academician, international sports lawyer, and has a lot of specialization in criminal law. He holds a master's degree in law and sports management and has received accolades for his academic contributions, including the Best Faculty of the Year Award. I now request Mr. Nishant Shekhar to please take the stage. So, on the panel, we have Mr. T. Gautaman, designated senior counsel who has vast experience for more than 24 years in the field of law. He has been the Chennai head of Messrs. India Law Offices, a vibrant law firm, and has represented various state and central government bodies. I now request Mr. Gautaman to please move to the stage. Mr. Nitesh Nagraj, advocate specializing in constitutional law, human rights, and taxation. With over 50 reported judgments in leading legal journals, he is recognized for his expertise in diverse areas of law. I request Mr. Nitesh Nagraj to please take his seat at the stage. Along with these panelists, we have Dr. Hemlata, Professor and Head of the Department of Forensic Medicine Toxicology at Sri Manakula Vinayaka Medical College Hospital, affiliated with Pondicherry University. I please request Dr. Hemlata to kindly take his seat. Over to you, sir.
Thank you so much. And again, thank you for the organizers to give me this opportunity. Before we start, I can understand that all of us have had, amazing lunch and we are at ease after having the lunch. But again, I would like to just request all of you with as much as energy you can accumulate, just give a wonderful round of applause to our panel members. Thank you so much. My aim was just to make everyone up and pay attention to us. So when we talk about the newer evidence laws or Bharatiya Sakshya Adhinaya, although it's a mouthful to pronounce, even though I come from north part of the country, so I'll limit myself to calling it the new evidence laws if it works for everyone. So the new laws are very interesting, right? They have renumbered, reconsolidated, reduced few sections, merged few sections, new definition for the documents have been introduced where they have included electronic evidence. And I think electronic evidence has been the major theme through which this newer law has been enacted and passed by the government and is seen as a future-proof or future-ready in terms of the technological advancements the society is doing, right? Apart from that, there are a few sections related to primary and secondary evidences, recognition of or clarification related to the electronic evidence in the Indian Evidence Act. So with that, I would like to just set the tone that we'll start with introductory remarks from each of the panel members, followed by questions by me, and then we'll open up the floor for the audience to ask any questions if they have. So first of all, Mr. Gautman, I would like to come to you for your introductory remarks and maybe your opinion regarding the new laws.
Good afternoon, everybody. Exactly about 11 months back, I'll tell you the exact date, 23/7/2023. Honorable Justice Anand Venkatesh from Madras High Court gave a wonderful lecture on the concept of proved, not proved in the Indian Evidence Act. So when he started the lecture, that's still available in YouTube. You log into that lecture, take about 7 or 8 minutes. He had made a statement saying that the best ever act that has been enacted in India prior to the independence and has carried on for the last 150 years is the Indian Evidence Act. He said that the act is so watertight that not a single provision of the Indian Evidence Act could be touched upon by any legislation. And he also said the only amendment we brought about in section 65 and 66 of the Indian Evidence Act has created so much chaos that I wish it was left untouched. Unfortunately or fortunately, the government appears to have taken it as a challenge and decided to revamp the entire act. And now we have an act which is more or less identical with the Indian Evidence Act. We'll explain later when the course comes. Certain provisions have been introduced, certain changes were overdue, but some of the provisions seems to be with regard to the reconstruction of the provisions, and certain clarifications or so-called clarifications have been added, which according to me leads to a whole new set of problems, and because of the ambiguity it creates. But it will lead to an interesting scenario as regards the dissection of the provisions. We'll have to see in due course as to what has happened, what is to happen, and like the moderator here made it clear, I think it's more with regard to secondary evidence and electronic evidence that the changes assume a lot of significance. More of it later.
I think just taking cue from what Sir said, that is predominantly the aspect of the new act, because the new act is nothing but the old act which has just been rehashed into various other provisions. The one thing which becomes extremely crucial in the new act, because a lot of emphasis has been laid in the new act to sort of streamline the system, is electronic evidence. By doing so, the government, in my opinion, and which we will definitely discuss in due course, has looked at two provisions where they have classified an electronic evidence to be a primary document, but at the same point of time have introduced the rigors for secondary evidence also to prove an electronic document. So that results in a lot of complications, and in particular section 61 and 63 of the new act, because both those legislations begin with non-obstante clauses. But I think overarching, I think as Sir said, I am in complete agreement. This is one of the best legislations which we had. So I'm not very disappointed that the new act is nothing but a rehash of the old act with some provisions merged and other provisions sort of just rearranged. So in that context, it's good. But what we must be very particular when we discuss the Evidence Act is that the endeavor under the Evidence Act is inquisitorial, to somehow be able to arrive at the truth of the matter. And that ample powers have been given to the trial courts, the way you ask questions during cross-examination. Everything the endeavor is to somehow cull out the truth. So I'm very happy to that limited extent at least, that the new act has retained those provisions, especially powers of the magistrate to pose questions to a witness so that the truth can ultimately be culled out. So those aspects are something which I'm in favor of, but the electronic evidence part is an aspect which I would definitely want to discuss further, but again, when we reach that particular position.
Thank you. Being a forensic medicine expert, and I'm not a forensic science expert here, I'm delighted to have gone through this BSA, because what the expert does know about the process of negligence or the mishap or the mistakes happening with human body is not being shown to the light of the judiciary or the law enforcement or to the advocates, the prosecutor or the defense. We capture many moments of the victim talking to us, the accused being very reluctant when we examine, and when finally we get to know our evidences become only corroborative evidence and not the evidence. We go back and we are vicariously traumatized, I would say. So this word of electronic, the other perspective I would say, I do resonate with the ambiguity. Only when we keep articulating the ambiguity, we will use our own perspective, our own expertise to try to integrate, break all the barriers of the expertise limitations, whether it's a personal or professional limitation, and we come at a point and say, come on, you cannot cheat us. It's not like you're an expert, you're a police, you're an expertise, you're a doctor, you're an expertise, and you're a judge, you're an expertise. Think of an accused, we talk about beyond reasonable doubt. Beyond reasonable doubt, that 1% also. And we don't want to convict an innocent. But think of the accused when he just goes out of all the trials, taking all the financials, human resources, budgets, policy making, SOPs, thinking that, oh my God, you left us, we never thought I'm accused. That really hurts the human value, I would say. So the one thing which I got really delighted and elated is, though you have to face this challenge in a very, say like a roller coaster ride. It's going to be a roller coaster ride because timeline, all these things we have to meet. Think of one person committing a crime in 1 second or a minute, and he's plotting to conceal everything, and we take in entirety, sometimes decades, years together, months together, or a couple of weeks or fortnight together, not unfolding the truth. So I personally am delighted to have had this inclusion of digital, electronic devices, even the microchips. They've added one word about semiconductors that really connected with physics, and it's really sparking to have had these inclusions. It's high time we should pedal up. We've gone to a digital, right from fast track down to transactions. In 1 second we do NEFT, IMPS and all this just for ourselves, and think about the others who are standing as an accused or innocent, either like per se or the other way. So it's up to us to become more smarter than the so-called accused, or to be more empathizing for the victim. I'm looking forward for the panel discussion. Thank you.
Thank you, panelists. When we talk about Indian Evidence Act and also the newer act, I am inclined to agree with the panel that this is one of the best acts or the laws which we have in the country. It's like a gem amongst the world of rocks. Even when we look at the mere definition of what is a fact, and you look at the words means and includes, it kind of captures each and every kind of evidence, fact which can be out there, and that mere definition captures that. And from that, the whole of evidence, the concepts of admissibility, relevancy, reliability, everything stems from the definition of fact. Right? So, and also I would like to take it from the first panel where the moderator mentioned that these laws have been there for more than 150 years, and we have been in a way adding few sections in a piecemeal to be with the technological advancements which are there, and that's what exactly evidence law also has done by including, for example, 65A or B, right, for related to electronic evidences. But now with this act, it has been streamlined when we talk about electronic evidences and also the definition inclusion of electronic evidences. So with that, I would like to come to you, Mr. Gauthaman. That when we talk about electronic evidences as one of the major changes which this law has brought about, how do you foresee it affecting the whole dynamic of evidence law with and resonating, if at all it resonates, with the legal practice for the lawyers, judges, and all the stakeholders who are involved?
Let me put it this way. Evidence Act used to have three parts. There were only three parts in Evidence Act, which comprised of about 167 sections. Now they made four parts. The first three parts, even the title of those parts have been retained. The only thing that has been added is the preliminary part, which contains of two sections. Beyond that, there is no major change in the structuring. The structuring is still the same. Like Mr. Nitesh pointed out, most of the sections, in terms of their essence, are retained, which is a good thing. I agree with him, because as we all agree, it is one of the best acts that ever came by. So retaining most of the provisions actually is going to help us in the long run. Now what has happened is, while retaining these provisions, certain phrases have been rephrased. Some changes are cosmetic, some changes are loaded. We are only worried about the loaded parts. Insofar as cosmetic changes are concerned, I'll give you examples. There were references to British Raj, British territory and all that. They have all been expunged. That was long overdue. That was a written provision anyway. On the other side of it, it did not have any bearing on the cases that were actually happening. So there were what you call vestigial provisions, which absolutely had no role to play on a day-to-day trial. Okay, insofar as the other sections are concerned, my major concern would be with regard to section 22 and section 61 and 63. Section 22 relates to confessions. Now, the law has been absolutely clear all along that an accused cannot be taken advantage of. If suppose a confession is taken from an accused, I'm sure most of you are aware that under the section 25 of old Act, any confession that is given to a police officer by an accused is inadmissible in law. Under no circumstances can that confession be relied upon by the court, except for one footnote, whereby if there is any recovery on the basis of the confession, then section 27 of the Old Evidence Act will come into play for the limited purpose of using that portion of the confession to extract something or to recover something. So that recovery is called a 27 recovery. So the law has been absolutely clear with regard to getting confessions from the accused. And there is something called extrajudicial confession, which actually talks about an accused going and giving a confession to a third party. Invariably, in all police cases, the accused should have gone and spoken to a village administrative officer, saying that, sir, I committed a crime. I think the police are going to catch me. I am worried about going to the police. I am scared of them. Therefore, I am telling you, give me a full confession. Now, this VAO and his menial will become the stock witnesses for the prosecution. This is how it used to be. Now, the earlier provision, section 24, protected the accused in the sense that the accused could not confess, or any confession given by an accused when he is in an inebriated state, when he is drunk, or when such a confession has been taken by way of a coercion or a threat or any such provision, then that confession was not accepted in law. Now that has also been watered down. Now they say the confession as under the old act will not be admissible if it is under the threat of a promise or coercion or a deception. But today they say the discretion is vested upon the court to decide whether such a position still continues, whether the threat continues, whether the promise continues, whether the deception continues. And it is always open to the court to discard that and take it as an offense, take the confession on record. They say that any confession which was otherwise relevant, but ultimately said to have been taken into deception, or when the accused was in a drunken mode, or when he was deceived by the police or any third party, is today admissible in evidence. Now think of all the sting operations. Anything that is said in a sting operation today can be taken as proof against the accused and can be treated as a confession. This is with respect to that. This is one major serious challenge. The second is with regard to electronic evidence. Electronic evidence, it was always a danger that was coming. With all due respect to Dr. Hemlata, I agree that we all should look at it from the perspective of the victim, and any delay is going to create a negative impact on the society. That said, there are certain areas that require tightening, but electronic evidence, like every one of you will agree today, with all the smartphones and all of you are a smart generation, you know that electronic evidence is always open to manipulation. Now, there is a provision which is being built in section 61 and 63 of the new act, which is almost akin to 65 and 65A and 65B of the old act. They are corresponding. Now, the only difficulty we have is, in the new act, they treat any electronic evidence with a presumption that it's a valid document. It is a primary evidence that is akin to any documentary evidence. Now, I have serious problems about that, because what happens is, if a presumption is made in favor of an electronic equipment, which we all know is subject to manipulation, that will not only prejudice the accused at the stage of trial, because at the stage of trial an expert would have come in, there will be an opportunity for the accused to establish that whatever evidence has been produced before the court by electronic means is not true. But at the stage of bail, the court, when it considers the bail of the accused, the court will be reluctant to grant bail in the face of electronic evidence. Because today, electronic evidence with the deepfakes and everything are completely unreliable. I feel the prejudice will start at the outset, not during the trial, because there is one other provision that has been included. Under old Act, section 65 and 65A and 65B, there was bound to be, particularly under 65B, any electronic evidence that is produced before the court has to be accompanied by a certificate, which is a certificate that is given by either the witness or the complainant or any other third party who was in charge of the device. Now, let's get one thing clear. Even before 2000, before the IT Act came in, Information Technology Act came in 2000, it was always open for a particular equipment to be produced before the court. Supposing you had a mobile phone or a laptop, you could produce it before the court, and the court would only look at the original and proceed further. Then there was an amendment which was brought about in 2000, whereby they said that any printout or anything from the computer could be taken, and that printout or any other material that is generated on the computer should be accompanied by a certificate. That is called a 65B certificate. Now, the 65B certificate has to be accompanied by an expert certificate. Now they say an expert has to also certify that certain provisions saying that this computer was only handled by one person, this computer was used repeatedly, data was regularly fed in this computer, and so on and so forth, which have been set out in the section. All of it will have to be certified by an expert. Now the problem is, the Act does not define who an expert is. The definition does not provide for an expert. In all fairness, Evidence Act never had an expert. Expert is a very relative term. But the New Evidence Act has taken a cue from the Information Technology Act. All those tightenings of definition okay, standalone computer, communication device, all those new phrases that have been introduced in the amended act actually have been borrowed from the Information Technology Act 2000. Now what has happened is when you borrow that, Information Technology Act defines an expert. There is a person called expert in electronic evidence. So that definition has not been brought into this particular act. Now who is an expert? And why should an expert be troubled at the time when a document is being produced before the court? Now, these two certificates, the certificate of the person concerned and the certificate of the expert, are mandatory documents. Both these documents will have to be produced for the document, for that particular document to be received in court. Now, admissibility is one thing. Admissibility of a document is one thing. Establishing the fact that the document was not tampered with is another. The expert has to give an opinion at a later point of time saying that the document and the computer or the device which was used to generate the document were not tampered with. That becomes a matter of evidence. Now, even for the admissibility of that, they have brought about a provision saying that an expert has to be done. Interestingly, under the old act, under section 65B, when a certificate is issued, there is no format. It is just an affidavit that had to be given, saying that I am so, I had this computer in my possession, this computer was not tampered with, it was with me for such long period, and it is totally under my custody and nobody else used it. This was the standard format. Now a schedule has been given, saying that this is the format in which the expert as well as the individual, the complainant or whoever has to give a certificate before the trial court, which is a welcome change. The only problem is the schedule that has been given does not correspond to the provisions. The provision says A, B, C, D are the requirements. But the certificate does not say A, B, C, D have been complied with. So to that extent, we see there are certain other things which, like I'm just citing one example. Like this, there are many provisions. For instance, I think he wants to speak about the non-obstinacy clause with regard to 61 and 63. So I'm not touching upon it. To put it in a nutshell, there is an ambiguity and mutual contradiction between 61 and 63, which actually throws a spanner into the entire change. The Act, the only good thing about the Act is that it seeks to clarify what electronic evidence is. Though it includes electronic evidence as a primary evidence, it creates a whole host of problems by bringing in two non-obstinate classes. Non-obstinate class is something that starts with notwithstanding whatever is contained in this Act or any other Act. So when you have two non-obstinate clauses and both are mutually contradictory with each other, then we are giving football ground for an advocate to play with. Basically, if you are trying to make things simple, okay. So if you are trying to make things simple, there cannot be an ambiguity in any act. Instead of tightening that, it has led to more ambiguity in terms of the only improvement it seeks to make in Indian evidence acts is my primary take on the topic.
Just continuing on that, in fact, I think the legislation itself speaks about the ambiguities. So let's just go straight dive into the sections itself. The one change which is there under this new enactment is section 2B. 2B defines what is a document. Now there, which was not there under the old enactment, under the new enactment, it says it includes electronic and digital records. Now this is of course a very positive sign, no doubt about it, because there's no point being in any medieval times. Ultimately, most of the evidence in today's day and age is electronic and digital records. So while this exists in section 2B, the next important provision is section 57. Section 57 speaks about primary evidence. Now one aspect I'm sure all of you are very, very clear, that we prove evidence. For you to have any evidence, you prove it either through oral or documentary evidence. Now oral evidence, if you've been a person who has perceived those particular events, you are competent to speak about those facts and prove it in a manner known to law. Now documentary evidence are of two types. One is of course primary and the other is secondary. Now, please see 57. 57 means that the document itself produced for the inspection of the court, and under 57, electronic evidence is included, and explanation 4 to explanation 7 speak about circumstances under which electronic evidence can be considered as primary evidence. So two aspects become clear here. 2B has undergone an amendment. 2D includes electronic and digital evidence. Electronic evidence has also been introduced as primary evidence. Explanation 4 to explanation 7 under section 57 speak about it. Now please come and look at section 61. 61, and I'm just going to read it verbatim. Nothing in this Adhinayam shall apply to deny the admissibility of an electronic or digital record in the evidence on the ground that it is an electronic or digital record, and such record shall, subject to section 63, have the same legal effect, validity and enforceability as other documents. So we pause here for a second. 2D defines document to include electronic evidence and digital records. 57 says electronic evidence is primary evidence. Once it becomes primary evidence, why must I have to fulfill mandates under section 63 in the first place? Because mandates under section 63 are to be fulfilled only if that document is secondary evidence. In fact, just as another example, if suppose you have an original copy of the sale deed, right? That is the document which is primary evidence. Suppose you don't have the original copy of the sale deed, then if you fulfill the mandate under section 65 of the old act, even the Xerox copy of the sale deed can be marked as evidence subject to fulfillment of certain categories. But that categories do apply only when you want to bring in secondary evidence into account. Now, by virtue of this legislation, 2D 57-61 says that this document, electronic or digital records, becomes primary evidence. Why then the mandate under section 63 at all? So, in fact, as Sir said, while it might give a floodgate of arguments ultimately to go before a court, because it can always be the case of, let's say, the opposing counsel, that even if, let's say, 2D 57 and 61 are fulfilled, if suppose 63 is not fulfilled, they can say, no, 63 is nothing but a rehash. 63 has not been fulfilled, and therefore this document is inadmissible. And let's mind you, all this is only on admissibility. They are only on admissibility of the document. After admissibility comes proof. That's a completely different ballgame. So if so much difficulties are created just for admissibility, then it really will open some floodgates. But it will be equally open to me, let's say as a counsel who introduces the document, to say no. Once it is primary evidence, then let's go by first principles. Once you declare it to be primary evidence, I don't need to fulfill the mandate under section 63 at all. Can be an argument which I could take. For this, I think it's just important to understand a little bit about the history of this entire legislation insofar as secondary evidence is concerned. Navjot Singh's judgment, which was the earliest judgment in point of time which dealt with this subject, said that electronic evidence, you prove it as secondary evidence, no difficulty. Then Anwar versus Bashir came. When Anwar versus Bashir came, they looked at the non-obstantive provision under section 65B and said, since there is a non-obstantive provision under section 65B, which said, notwithstanding anything else contained under the Evidence Act or any other law, they said that is a specific provision. Because that is a specific provision, you will have to introduce the certificate under section 65B. Otherwise, the document is inadmissible. This is what P.K. Anwar versus Bashir said. Arjun Pandit Rao, which is the three-bench decision of the Supreme Court, followed Anwar versus Bashir, and Justice Nariman opined that no electronic document can be accepted without the mandatory section 65B certificate. In fact, Justice Ramasubramanian went one step further after analyzing the entire provisions about the importance of electronic records and said, ultimately there is always a scope of misuse. And so because there is a scope of misuse and the way our constitutional structure is founded, that you can have even 100 scoundrels go scot-free, but not one innocent man should be punished. They said that ultimately these aspects will have to be borne in mind when the document is ultimately admitted. Now it is in the backdrop of these three legislations and so much of confusion that the new aspect came, the new act came into being. We expected that the new act will sort of ease out these creases, but in fact it has complicated the creases a little bit further. Because I really don't know how I can reconcile 61 with 63. Because now I just read section 63. Section 63 says, notwithstanding anything contained in this Adhinayam, which is the same language which is used under section 61, any information contained in electronic record which is printed on paper, stored, recorded or copied in optical or magnetic media or semiconductor memory which is produced by a computer or any communication device or otherwise stored shall be deemed to be a document if the conditions mentioned in this section are satisfied. Now, one may easily argue that no, please see section 61. Section 61 says it will be deemed to be a document only which is subject to the conditions in section 63. That's why I go to the fundamentals. Once you say it becomes a primary document, and it becomes primary evidence, there is no necessity for me to satisfy the conditions under section 63, which then become completely secondary evidence. And that aspect of the matter, I think somewhere the legislation has somewhere fallen foul of it. But as we were just discussing even before we came up to attend this matter will invariably go to courts, and courts will ultimately have to solve this problem. So I think that's an issue which ultimately this legislation has not given much clarity.
Yeah, so I would like to first reflect upon, what Mr. Bharatiya mentioned regarding the confessions given to a police officer or in a custody, right? Earlier, if we look at when the provisions of confession in evidence law, and then with CRPC, right, when the magistrate is recording the confession, there were safeguards put in place so that if the confession is taken under any influence, outside influence, undue influence, threat, promise, anything, the magistrate could make sure that such a confession was not ever recorded. It would be interesting to see whether the similar provision and the practice have been retained in the newer laws or not. Right? And when we come to Section 61 and the contradiction with Section 63, Section 61 clearly says that the treatment of electronic records has to be as same as the documents, the physical documents which are there. Similar rules will apply if you are treating them similarly. Right? But at the same time, the 63 creates a problem, and I think rightly pointed out by Mr. Natraj that it will be upon the courts to adjudicate on the issue and the contradiction which is there. And I think it's usually rightly said that you have to be very careful when you are coming out with a sequel of a very perfect movie, right? I think the similar logic would also apply to Indian Evidence Act in full, or the sections of primary and secondary evidences. With that, I would now like to come to our third panel member, Dr. Hemlata. She has a very interesting background, which is medical forensics, right? And throughout today, we have seen each panel, including Inaugural, has talked about how the role of forensic experts is going to change. The kind of impact these three new laws are going to have on the field of forensics, right? And if I take a provision from CRPC and evidence law, now the forensic experts are required to be there for certain kind of offenses, to be there on the spot at the crime scene, record everything, right? In a way, it is increasing the inclusion of forensic experts in the investigative process. Right? So, how do you think this kind of change and inclusion of forensic experts is going to impact the experts who are currently there and the whole infrastructure? And do you think the forensic science or let's say the experts are ready for such inclusion?
So, though I'm not a legal expert, I could follow with my panelist languages in the name of a layman sitting along with a panelist. So, what I feel was probably when all these laws and acts were made, they would have gone for an Excel sheet. They would have had a IT professional, inclusion of acts, inclusion of bills, no other, each section contradicting the other, or one section, one act is contradicting the other bill and act. So we've been having this juvenile as 16, 18, for a long period of time, age of marriage was increased. So when we had cases of abortion or termination of pregnancies in the hospital, we didn't know what take we should take. Because the consent again is 18, and the age of marriage was 18, and juvenile was 18 as of now, because it is gender neutral, age neutral. We just blended up all the deficiencies and gaps of POCSO. After POCSO came, at least we were in a good sense to address the context of age and consent. And OGs hardly know. Even last week we had a class, if you could have time, let me share that. We had a class from the OG department for the MBBS students. The entire topic of MTP touched about only 1969-71 Act. Not even a single word was shared by the expert team who is going to deal in real time. OG department, the obstetric and gynecologist, majority of hospitals, they are the first contact of handling the victims right from the age of 3 down to whatever the age higher up to. and she is about to graduate, get herself graduated with MS/OG. Though I'm reaching the integrity of my professional, I'm compelled to communicate to this forum because you serve as an intermediary or an expert to tweak all those deficiencies from the other expertise, I would say. So what I feel is, I think judiciary, as you said, the deficiencies, contradicting each other, the next consequence, like no one but the next number, and certain accent will say something, and when you are all into judiciary and legal, think of the other fraternity hardly knows about the A to Z of laws and sections, except for the medical laws. So, though I could understand that 6163 contradicts with regard to primary and inclusions of these electronic, I think all of us would remember, majority of the cases now go for media trial. And majority of lawyers and judges just gets up in the morning and just wants to look at what videos have gone viral before they go to the court of law wearing the black coat. All those evidences, which would be very difficult for the judges and lawyers to just get it in, physically in the court, probably say wall to wall. We see it in the phone. So we see one video early morning. There is a vehicle which is like very fast on the road, and something fell down from the vehicle, and it was Coimbatore, the main trunk road, Avinashi High Road. And we got to know, it was like recap, the channel was just like doing it again. It's hardly probably 20 seconds, less than 20 seconds. And we got to know body which just fell down from the vehicle. And everybody would have thought we have a kind of world of imaginations, I would say. And I don't know how many of us got to followed it or spoke with some expertise to know what really happened. Was somebody killed and accidentally the body fell when they want to take and conceal it? And I accept that it will be ambiguous. There will be a lot of imaginations, whether it's going to stand with the credibility, whether it's going to be admissible. But at least with the word of presumption, umbrella word, I think it could be considered. Instead of not having an accused during the trial, not having any evidence at all, probably we would use our own expertise or our own mindset to decipher and discriminate whether it's going to be considered or not. As you said, proven, proved, unproved, not proved. Probably we could bring that all together into an unproved at least. We do have some evidence, so it's going to be forged. And we had some session with Tamil Nadu Ambedkar Law University with Codex, where we had a beautiful digital cyber forensic experts. So they said they all shared that it's nothing for us to scrutinize all these evidences, whether it's going to be a fake or not, anything and everything. So they had the expertise. He was one, Dr. Bhaskar, he worked with Scotland, he's right now out of the country. So they had expertise. Why don't we pull in a lot of expertise and just not, no, I'm not against your take. Why don't we still criticize about how about admissibility, how about expertise? Probably we should hand over the ball to the authorities, governing authorities or administrative or government to just start with giving us funding for or recruitment of faculties or trying to put all of us together at one-stop center, at least online. We do have time, provided I think we should be willing to take it up. It's so easy for us. That willingness is missing, that's what I feel. And ethicality and our fiduciary duty is now into the platform. So, many such cases I would say. During COVID, when doctor died, because the duty doctor did not attend. Then we saw the CCTV, the urine bag was full, and the doctor asked, my bag is full, I'm not able to urinate. I think catheterized. And he died because he couldn't urinate. We have only such non-medical evidences which happen to be in evidence in CCTV. Though I might sound so infantile to you all, because you're all dealing with giving judgments and verdicts and thinking in context of bails and not bailable or compoundable, summary, and all those words of judiciary languages. Sometimes all such evidences has to be at least considered. And even with rape cases, I'm sure that we don't have faculties and doctors to attend to sexual assault cases. I'm not talking about the quality doctor. I'm not talking about the skill of the doctor. I'm just talking about we don't have doctors. We don't have doctors to examine or address. They make them go to pillar and post. If they go to a primary health center, they say, oh, this is an emergency case, go to the secondary care center. And secondary care center, there's a maid sitting there, there's a duty doctor, only doctor, a drawing officer. And he sends that patient to the general hospital or district hospital or a medical college hospital. And where is the evidence? And we are pushing the police officials to get it done within 7 days, or with the forensic scientist to give about the report about what happened. And it's not like all evidence is collected from the victim or accused has to go through a process. Like, no, police has to come, collect it. Even in case of death cases, rape and murder, they have to come pick up all the containers. Hardly they come, they say, one of duty police varla. We keep it. There are many stations. It's not only about Tamil Nadu status. You go to Osmania, about 100 plus containers are staying. And it's not like those investigations could be done only by a forensic scientist. Even forensic medicine experts can get it done. Why do we delay just because we don't get to know the gaps between the expertise? In 1 minute, we can just, whatever the smear which is made on the slide, you can put it in a microscope and say, it has a sperm, it has a moving sperm, it has an intact sperm. And what we talk about patients, medical crime or crime dealing with human body or crime dealing with medical personalities or forensic, we carry this gadget everywhere. We don't talk about ostrich or a plant or animal. We are dealing with the human body, and all our accused, suspects, or victims are all human body. If you could know smallest thing of the human body, I think it's so easy for all of us to mend the gap between the context, I would say. So that is my take. So many of the evidences could be at least put an umbrella word of unproved evidences and probably circumstantial evidences. Thank you.
Thank you, Dr. Bharatiya. When you are talking about proving of an evidence or unproving something, right? When we consider the field of forensics, they're not just important for the evidence law. We can look at any provision of, for example, IPC or CRPC. The law has deep into the forensics file if you want to prove a particular crime or how to go about the process. Or in fact, we as seen in the Indian Evidence Act also, right? For example, let's say we talk about section 112 of the previous law, you cannot prove paternity now without the DNA proof, right? But earlier it was the conclusive proof which was raised, and DNA even couldn't refute that kind of evidence, right? So it would be interesting how the field of forensics adapt to the newer laws. I definitely come to the capacity part of it to you, but before that, I would like to come to you, Mr. Natraj, where you mentioned the judgments, right? For example, Bashir or Navjot Singh. And when we look at the newer laws, the initiation or coming up with new laws in a particular country doesn't happen so often, right? It is just once in a lifetime opportunity for some to introduce few things, plug certain loopholes, and at the same time include the judicial precedents which exist. So with that, looking at the newer laws and these judgments, very important judgments, do you think the newer Evidence Act has failed to plug these loopholes and also consider the legal precedents which exist?
Well, since I started off by saying that ultimately when you look at it, the new law is nothing but a rehash of the old law. So to that extent, Indian Evidence Act 1872 still very much continues under our books. It's just that it's differently named. Apart from which I don't see a change. Where there was a sort of an avenue which they could have really applied their mind was of course section 61 and 63, which I feel they have somehow failed to do. But I have to correct one aspect I just wanted to say. See, when I say section 61 and 63, it should not be misconstrued that I have a problem with two non-obstante clauses. I mean, if that was the only issue, then it would have become very difficult to reconcile. But that's not how, it's not actually, that is not actually the problem. Because 61 specifically says subject to section 63. So since it says subject to section 63, it is ultimately sent to a court. The court is going to say 61 will definitely have to cede to section 63 because 63 is the provision which actually applies. But it is fundamentally the principle which is the problem. The first principle is that how is it that when you have primary evidence, why do you even have to prove it in terms of secondary evidence is going to be the issue. So that is where I see there is going to be a divergence between section 61 and 63, not in terms too much of having two non-obstante clauses. So while that being said, I think we've spoken enough about electronic evidence, we'll park it at that. Judgments have come, judgments have gone, but those provisions have interpreted the old law. Now we come to the new law. But in terms of the new law, one important aspect of the Evidence Act which we must really appreciate is, it is a marvelous piece of legislation solely because while of course IPC and CRPC is exclusive to criminal matters, Evidence Act is all encompassing. It applies for your civil proceedings, it also applies for your criminal proceedings. And the way it is ultimately structured, in fact, I heard ma'am and ma'am speak with a lot of passion. But I think the answer actually is in the Evidence Act itself. All that the Evidence Act ultimately says, when you look at the definition of proof in the Evidence Act, it says, if the facts are so probable, which makes a person believe it to be true, then that fact is said to be true. So at the end of the day, the Evidence Act focuses largely on logic and nothing else. But while we keep logic as rather the end goal, the means to achieve that logic is what the Evidence Act speaks about. So therefore it categorizes what is admissible, what is relevant, what is irrelevant, and then ultimately to see whether you can actually prove it. So certain aspects, for example, electronic evidence, as Sir also touched upon, are matters in which it is very, very easy to morph. For example, the new legislation says, if the same copy of a particular evidence is stored in different formats, each of such formats will be deemed to be primary evidence. So therefore, let's assume there's a video recording which I have on my phone, and I decide to send that video recording to a friend of mine, say like via WhatsApp. Then even if it is on my friend's phone, it is also deemed to be primary evidence, right? Now these are certain problematic areas because it is definitely prone to some level of misuse. But that being said, it is important for the legislation to have those filters because otherwise we should not become a police state. Because the danger is you can keep anybody, send anybody, build up whatever evidence which you want to against somebody and then prosecute just for the name of prosecution. That's not the endeavor. We don't want to become a police state. So checks and balances are there. So for you to identify what evidence is admissible, these are certain checks and balances which you just have to follow through and ensure that you succeed at them. Second aspect of it is what are relevant facts. And that's why I think since most of us are lawyers or going to become lawyers, these are areas which we have to focus on very, very deeply because many times we see in courts irrelevant facts are ultimately spoken. We have to bring it within the contours of the Evidence Act. What is a relevant fact for me to actually speak upon? Now when Evidence Act says in civil cases, character of a person is irrelevant. Now, whether I happen to be a gangster, not a gangster, whether I happen to be a womanizer, not a womanizer, is irrelevant for the purpose of a civil adjudication. And that's what the Evidence Act says. But more often than not, we see in majority of our litigations, we see mud being thrown, character assassination which is being done in civil cases which is irrelevant. So all that the Evidence Act sort of tries to bring in is streamline this entire sequence and which will ultimately ensure that it results in end goal. But it has so many beneficial provisions. One of the old provisions, which is 165, which continues under the new legislation, as I mentioned in my introductory remarks, is the power of the court to pose questions to a witness. Now, usually, every time when we speak about cross-examination, we always look at it as an adversarial combat, where the counsel is cross-examining a particular witness. Here, there is a subtle change. The court has the power. Let's assume, like as ma'am said, that no matter what, the prosecution has not really brought its evidence in, and let's even assume that the prosecutor has not posed the tough questions on the witness. The court is not powerless. The court still has the power to pose those questions to that witness and somehow elicit truth. Apart from which, the court also has powers under the CRPs. If it is dissatisfied with the investigation, reject the final report and order further investigation. So powers exist, but at the same point in time, we must also ensure that our personal freedoms, 19, 20, 21, are so sacrosanct. All laws under the ground theory are obviously subservient to the Constitution. We don't do anything which falls foul of the Constitution. So I view this legislation as a brilliant piece of work. All that it does, it just streamlines the process and ensure that ultimately we can prove the branches a little bit. And if this is applied in its proper perspective, justice will be served.
Definitely, I agree. When you look at section 165, right, it is one of the best drafted sections in the previous Evidence Act, which gives unparalleled powers to the court to pose any kind of questions. bring any document. Whoever is present in the court, just ask anything related to the case, right? And in the interest of justice. So Mr. Nataraj also mentioned about, the kind of protections we also get from the Constitution and evidence, including those protections under the newer law also, right? So again, I would like to now come to Mr. Gauthaman and ask, let's say it's my personal curiosity related to this particular question. So I would like to take this time and ask us this question. When we talk about right to privacy and then when we talk about Indian evidence law and the kind of cases we have seen, Evidence Act does not talk about, for example, illegally obtained evidences. It is very clear on the custody of the evidences, but it is not clear on where you get your evidence, how you get your evidence, right? As long as it is there, it is properly in the custody, you can use it in the court. I think 1955 Privy Council judgment gives you that power to use illegal evidences. India does not recognize, for example, the concept of fruit of a poisonous tree. So having said that, do you think this was an opportunity to include a concept like fruit of a poisonous tree, considering the right to privacy of the individual?
I think it's partly covered under section 22 of the BSA. As I told you, the word deception that is used here probably covers most of what you said. Because I'll go under the old Act, section 161 of the old Evidence Act had something called a privileged communication, which also gets extended here. Unless the communication, there are certain categories of communication, like a source of a police officer need not be disclosed. Any communication or information given by a client to his lawyer or a patient to a doctor cannot be testified in a court of law. It cannot be asked as a matter of right. Certain amount of protection was also given to the press. But today, press's liberty has been more or less taken away. Even the Supreme Court has made it clear that when it comes to issues of national security or something or a gruesome offense, any information that is available should be made available to the investigating officer. So to some extent, I think that issue has been addressed. My bigger problem is violation of Article 20 subclause 3. See, Article 20 subclause 3 gives a protection for any person against self-incrimination. No person should be put in a position where he does or says something that will potentially convict him. See, there is something called Miranda rights in the US. When a person is bound to be arrested by the police officer or is being taken for an inquiry, they had to read out what is called the Miranda laws. There are two laws. The first one would be to tell the person concerned that you are entitled to have your own counsel. You are free to have access to your lawyer. And the second is most important. It is to be said very clearly that anything that you say now can be potentially used against you in the court of law at a later point of time. Now we all know about our police. How realistic do you think for a police officer to call a person and say, sir, please come here. We are investigating you with regard to an offense. Anything that you say now will be used against you. Bad enough, whatever you don't say is recorded as a confession. Today, we have to all understand that there are two types of creative writings. All of you, I'm sure, are going to be budding lawyers. I wish you all the best. There are two types of creative writings you will come across. The first creative writing, probably a rudimentary level of creative writing, would be the FIRs. Okay. The second most creative writing would be the divorce petitions. Okay. So this is something you are going to encounter in your lives when you are beginning a career as lawyers. Now, I'm not putting it against all the police officers in the country. I'm sure there are a hell of a lot of very upright and honest officials. I'm not putting it against them. But there is always a pressure for them to bring somebody under the scanner. So, more often than not, the first person, either two things happen. They find the accused, they decide to make sure that he goes in, so they amplify the event, exaggerate the FIR and ruin their case. Or they find the first passing victim or somebody who is caught in a petty case in a police station is made an accused. As much as I empathize with Dr. Hemlata with regard to how experts are being treated, the so-called skills of a cross-examining lawyer, she said we pick find faults or we get into technicalities. That's called cross-examination and legal parlance, by the way. Now what happens is, unless you have been a victim or you see somebody who is a victim, you'll never understand the other side of whatever you see or read in the media. Because today, whatever you see in a police case, all I can tell you is, you do 3 criminal trials. By the 3rd criminal trial, you'll realize what you see in the newspapers and the TV have nothing whatsoever to do with what actually happened. I'll give you an example. There was a high profile case. There was a case where there was a police sub-inspector, not even an inspector, sub-inspector in Tanjavur, who had a problem with his neighbor parking his bike near his premise. They had a dispute going on. Apparently, the neighbor was parking it in such a way where his access to his property was being cut off. Because of this issue, there was some personal enmity between both of them. Now, what happens? This gentleman gets transferred from Tanjavur, goes to Tiruchi, and gets promoted as an inspector. He gets to investigate a case of a very high profile case. I don't want to get into the details. This involved a huge victim, and it involved a lot of official pressure from judiciary as well as from all quarters. In that, 10 people were cited as accused. You know what happened? This neighbor was brought in as the 3rd accused in that. This poor gentleman was living in Tanjavur, he had nothing to do with this. Just a personal enmity. I'm not saying that this is the norm. If something like this happens, the judiciary cannot straightaway assume that all 10 people have to be brushed with the same stroke. The expert is going to give an evidence. See, what you have to sift, basically, the shaft from the rice is what the judiciary has to do. If you are going to go by emotions and one stroke judgments, which qualifies, law cannot be blind. Law can be blind to the individual in front of it. Law cannot be blind to the evidence available before that. As Nitesh beautifully put it, our endeavor is to find out whether the laws have been properly followed and the principles of evidence are being properly applied. If that is done, there is no reason at all. I will tell you from my personal experience, I have been doing trials for 25 years now. I will tell you, the most difficult witness to cross-examine is the witness who is saying the truth. If the witness is saying the truth, it's next to impossible to impeach him. Even if a lawyer with all his skills as a cross-examiner manages to sidetrack the victim and extract something, that's where the role of the judge comes. The judge will be able to put a question and bring the cross-examination back into track, so as to ensure that the purport of the answer is properly clarified. Now, if you say something, the judge will immediately say, "Sir, this is what the advocate is saying. Is this what you are trying to say?" If the prosecution says that, we can immediately jump up and say he is trying to lead the witness. But if the judge puts a question, nothing can be done. So let's not labor under this delusion that we are living in a perfect state. If you want a perfect happy ending, please go to the theaters, watch some entertaining movies. That's not done. Some crimes will remain undetected just because there needs to be some kind of a closure. A victim cannot go in. So experts and advocates have egos. We want to protect our clients, we want to protect their opinions. But the fact remains that there is a midway in between where a person who can be a gullible, innocent person can be victimized. So the endeavor of Evidence Act is to ensure that such travesty of judgment does not happen. That is the only endeavor. So long as the law is tight and we follow the norms, more often than not, we'll end up on the right side. Because the judges always have an instinct. The conviction of the trial courts are usually correct. There may be some technical aspects in which, by which the accused may get away, after being convicted by a higher appellate court or something. But by and large, the convictions based on instinct are more often than not perfectly correct.
Thank you so much for your observation. And definitely, when we talk about self-incrimination, right, it exists. From, for example, if you talk about a police officer asking for your password of your phone, does it amount to self-incrimination when you are giving your password to the police officer? Right? That is also something to think about. And if we talk about, I think the happy endings, I think even in the movies, these don't exist, except in the movies which are based on the true stories or allegedly the true stories. Right? So, talking about the positive side of the things, and now I would like to come to you, Dr. Hemlata. The newer laws seems to be going on the track of including all the technological advancements which are there, and also in a way being future ready for it. Right? So how do you think or what do you think should be done from, let's say, being from the perspective of a forensic expert to properly build those capacities or to train people in forensics to, in a way, be at the same level where the law proposes to be?
What I feel is it should start in medical school. With the syllabus and curriculum of the legal school, medical school, police, and equally academy, police academy, judicial academy, should have some competitions, interactions between our students. That's where it starts, because just when you go look at the back, they say forensic medicine, it's a subject which should be learned over the night for exam. That's the real take of the medical students. And these are the students who go to the district hospitals after being recruited under Medical Recruitment Board, MRB competitive examinations, and they sit in all district hospitals. They are the one who conducts the autopsy, they are the one who conducts the medical examinations, and majority, I think, the judiciaries would accept with me all the postmortem certificates and the rape certificates, the drunkenness certificate, except for the AIDS certificates. Probably radiologists will be there, and orthopedician will be there to look at the association centers and give the AIDS certificate. All the other cases, all the reports are majority being given and signed with MBBS, casualty medical officer, duty medical officer, or he happened to be a nephrologist doing an autopsy on this duty day. Again, it would have deficiencies. I think majority would accept that. They come over to the forensic doctor nearby medical colleges after 2-3 years and they ask like, no, is my certificate right? This is what is happening with forensic medicine. And with forensic science, again, we do interact with the forensic scientists. Majority, they complain that validation, equipments, and hands, courses are being removed and recently started MSc Forensic Science. They switch over to medical school for teaching forensic medicine to forensic scientists. I think at all level, if you could integrate and get things done, only then we could think of all this electronic or evidences per se. And the speedy trial, all this timeline limits, I do not know how we could meet up, and it's going to be a huge weight on the judiciary and the legal fraternity. So, actually speaking, we are not ready. And one more point I want to add on to is, if there is a zero FIR, none of the states have a uniform certification. None of the districts have a uniform certification. None of the designated expertise have a uniform kind of certification. One judge might receive cause of death alone. Another will receive cause and time of death. And we don't have a uniformity. Number two, again, I'm trying to emphasize again, majority of the cases, though we understand the trial and accountability and responsibility of the judiciary and the lawyers, defense or prosecution, majority of the evidences are considered as corroborative. There are certain biological evidences which just speaks only one entity. If we could have some kind of forums like this, or a regular forums once in a fortnight with judiciary and lawyers, I think that would address about not setting apart such evidences. So I think the knowledge which has to be shared between the fraternities is the first takeoff we should start with. Thank you. And regarding one more point about disputed eternity or illegitimacy or legitimate child, it's not about the one DNA. A simple blood grouping test will speak about, at least it will screen about whether it's exactly exclusion. Though with DNA we have like 0.0001%, again with twins. So there are certain stigma about certain facts, and there are many facts which has gone obsolete, which still courts are sticking on to. The young doctors, or the they have some knowledge. I'm not putting down the knowledge of the seniors; they're much more well versed with experiential-based practice and knowledge. But still, we have to mend up both the ends and get back to a shape of what have become obsolete, and what is newer technologies. And it's all about education and willingness to learn and get ourselves integrated. So that integration and multidisciplinary approaches, I feel it's completely missing, I would say, except for experts who stays in the metropolitan cities. And I wonder what's going to happen with the rural evidence collection, forensic lab, mobile labs, district forensic labs. I just can't think of when are they going to know there is such new law.
They say some new law has come, many don't know what are they up to, and we all talk about it's going to start on July 1, the Doctors' Day, and Doctors' Day you could have a forum for the doctors. You're wondering what is the topic about, what is the abbreviation for. So I think we should tread up higher to enhance ourselves, to integrate and fill in the gaps. Thank you so much.
Just one thing, in fact, Nishant, when you mentioned, just thought we should flag this. I was very disturbed by this word cooperation. Because Sir also spoke about it, Article 23, you have a right to remain silent. If I have a right to remain silent, because I see this on a regular basis, every time, even bail orders are mechanically passing, cooperate with police. Cooperation means what? If you call me, I can come. If you ask me for certain information, if I wish to give, I can. But otherwise, I have a right to silence. I have a right to simply say, I'm not going to give you anything. If I have a phone, I'm not going to give you my password. You cannot open or access my phone. And somewhere I feel the new act, because this problem has been continuously going, and especially with these new laws which have come insofar as economic offences are concerned, where reverse burden is introduced, becomes a very problematic affair because they come up with an avalanche of information against you. Now, the presumption is that you are guilty. You have to show reasonable material to show that you are innocent. But when you go before the investigating officer says, give me this detail, give me that detail, basically asking you to solve a crime which you have not committed. Let's assume it like that. And if you don't want to take him through any A or B particular direction, he immediately writes to the court. And he will tell the court that this gentleman or this lady is not cooperating. Now, that I feel is a very, very serious matter, which this enactment had an opportunity to sort of really go into and say, to what extent is an accused entitled or rather mandated under law to cooperate, given the sanctions under Article 20 clause? That's an area where they've sort of not gone into. There is one grey area here where they say, if suppose there is electronic evidence in which some information has been retrieved, which was not in your custody, then that electronic evidence may not be admissible. But then again, the reverse presumption is against me. But as ma'am has also been saying, with the sort of hype which surrounds the matter rather than the matter itself, and as sir rightly pointed out, when you actually go to the court, very little of what is actually spoken in the electronic media, what is written in print media actually comes up to the case. This sort of this presumption of guilt will make it very difficult for a person to even get bail. Let's forget trial. And sir correctly said the biggest problem for any particular person as an accused is not proving innocence after a prolonged trial, but that arrest. When that arrest happens, when he's arrested and taken to the police station and lodged in jail in front of all of his neighbors, that's going to ultimately shatter the person. At that stage, when this sort of material is shown against the person, and the presumption is that it is yours, and if you say, I am going to remain silent, I'm not going to cooperate, that is also held against you. Is an area which I felt this legislation would have definitely looked at, but unfortunately it didn't.
Definitely, I am inclined to agree, and not inclined, I agree with you when we talk about the right to privacy, when we talk about self-incrimination. These are the issues which have been existing, and I believe this was a missed opportunity from the perspective of evidence law to plug this gap and to provide more clarity on, or could have provided more clarity on these aspects. With that, and looking at the time, I would like to now open the floor for questions. We have time to take 2 questions. So, if any questions in the audience. So we have 1 question this time.
Good evening, sir. I am Kritika, student of Vinayaka Mission Law School. I had a doubt currently legal proceedings and debates are taking place to electronic device using online platforms. So documentary evidence is submitted in online. If there is any instance of trafficking, are there any provisions in the new CRPC that address this?
Although the panel deals with evidence law, but if the panel members would like to take the question.
In fact, I was going to say that. I mean, like, this question would have been better directed at the previous panel, but nevertheless, I'll take it. Let's be clear about one thing. Yeah, it's an afternoon. I can understand if you went into a slumber and then just woke up. So, but let's understand this thing. The gravity of the offense has nothing to do with any change in the investigation procedure. Be it a murder, be it a theft, be it even a pickpocket. The standard that is prescribed for investigation is one and the same. There is no change at all. So if law permits a device to be accessed, it is permissible. If a law permits a device to be accessed for pickpockets, then the same law will apply for trafficking also. Even for child trafficking, unfortunate as it may be, the law does not change with regard to the offense. The law is one and the same. So there's no change in the procedure, investigation. The only issue now is, which is all really become the bugbear of the nation, national security. So that was one proposition that was repeatedly being used, saying that when issues of national security are involved, then the right of privacy has to take a backseat. So this was one area which is, but the Supreme Court has recently clarified, saying that no. Even if it involves national security, you have to establish before the court that there is a genuine case of national security. Just because you invoke NSA does not mean that the privacy can be breached into. Because privacy is sacrosanct, Article 19, 20, and 21, as he rightly pointed out, are non-negotiable. So if you're going to breach that, there has to be a really, really bigger cost, higher cost. Unfortunate as child trafficking or child pornography may be, that still does not give any special power. If a law is laid down that way, that has to be tested against Evidence Act and CRPC, and a special exception has to be made for it. As of now, such a provision does not exist.
Are there any other questions? There is time for one more question if anyone has any questions.
So you were talking about electronic records being primary evidence, and hence you don't have to go to 63. But then I just saw through the provision and I saw explanation 5. It says an electronic record, if proved to be under proper custody, can be primary evidence unless disputed. So I was given to understand that if it's disputed, we go and take the records under section 63. So am I right to assume that? And just following up on it, it says unless disputed. So I can dispute a document at 3 stages. One, when they produce it, the other when they're trying to market, and the other during my argument. So if somebody is to dispute my electronic record during their arguments, how do I go back and follow the procedure under 63?
Let's take it this way. The first part of your question, you are right. But let's say there is a dispute in terms of how the legislation is presently worded. Even if it is primary evidence, I still have to fulfill it in terms of section 63, because that's what 61 says, subject to 63. My argument was on a fundamental proposition saying, if it is deemed to be primary, then why do I even have to go by 63? But let's say, as per that explanation, since that document is being disputed, the court will have the power to see whether that dispute is genuine or moonshine. If that dispute is genuine, then obviously the mandates of section 63 will clearly apply. But if it's a moonshine defense, suppose it was a cell phone which was always in my possession, you merely to sort of pick holes in that document which I sort of produced, say that you are objecting to the same. That does not necessarily mean that it is a genuine defense, it's a moonshine defense. Now, once the document is introduced, that is only at the stage of admissibility. Now you have your objection, you can always say that this document was never in my custody. Okay, it was actually a document which was under your custody. I took it from you and thereafter I produced it in court. Now, that does not necessarily have any bearing on the admissibility per se. The document has come into being. Now, the court will consider it at the stage of trial, in which you can read evidence on to say how at no point of time that particular electronic document or device was ever in my custody. And the court at the time of pronouncement of final judgment will ultimately decide as to whether that electronic document can actually be paid any heed to or not. So the stage is what we were all discussing now is on admissibility per se. But that does not necessarily mean that post that, once the document is just merely introduced in court, the court is going to presume every content of that document to be true. If you are raising a defense that it is disputed, you are entitled to raise it during trial. And at the end of the trial, the court feels that no, I agree with you, that in fact it was never in Nitesh's possession. Then the court is going to say that this document cannot be treated as evidence. Trust that clarity.
Now, coming to electronic evidence, what I understand is that you have to produce a section 65B, which is conforming to section 4, to the court. Now, who is the authority? It is the person who is owning the equipment or the electronic device. After producing the evidence, which is not in primary evidence, is a secondary evidence. Because he stored the information from the mobile into a computer, and from his computer he's taking it out and producing it in the court. Now, is such an evidence produced in the court authentic? How do you certify it? The courts say, go get it certified that it is authentic. The person who is producing is always going to say it is authentic. But how many certifying agencies do we have to say or prove it? Because the information and the reading material that I've done is, if you go to a cyber expert, he'll be able to tell you whether this is authentic. But where is the primary? My phone has gone bad, it went redundant, and it's no more in use. But it's from my computer. And now computers have so many apps where you can modify, edit, morph, and do whatever you want, tamper with evidence. How are we to prove it to the court that this is a wrong evidence, fraudulent evidence, created evidence?
See, one thing which at least in the cases which we have done, subject to what Sir says, we always look at hash value, right? So if there is any sort of tampering in a document, the hash value varies. If the hash value remains the same as what it originally was, then there doesn't seem to be a difficulty. But let's say in a given case, what you're saying is your primary device is gone. Let's assume it's formatted, right? You saved it up on drive, right? Now anyway, under the new enactment, drive is also considered to be primary evidence, right? So from there you take a printout and you ultimately produce it before a court. Then the certifying authority, now of course they have given a standard template under 65B4, will be in a position to examine as to whether the hash value is the same or not. Now I'm not of course an expert on how forensically we must view it, but hash value has been a practice which courts have adopted to say if the hash value stands, then the document has not been tampered or varied.
Suppose in this particular matter, we are giving you a screenshot of continuity of evidence, which you have given a part of the evidence, not giving it in full form. You have edited it. Only what suits your convenience, you're producing it as evidence, and what is suiting the other side's convenience, you quietly edit it. And the screenshot is as good as a Xerox copy of the original document.
No, it is not. Let me stop you here. Screenshot is neither here nor there. Anybody can manipulate, which is why you need the device. What happens is a screenshot. Supposing my name is Gautaman and your name is, sorry, what's your name, madam? Nayan. Okay. I can store a name by name Nayano. I have an alternate number. I store a name Nayano and I send a message to myself calling me names. I take a screenshot of that. Does it even establish that Nayano has sent that message to me? So if you take the device, they can cross-verify to find out whether or not Nayano corresponds to that number, and then go back to the call records and verify whether such a message has been given. In the case of WhatsApp, it's encrypted, that cannot be established. Which is why WhatsApp is a very big kind of evidence. Let's understand something about evidence, electronic evidence. You have a number, I have a number. At best, the call records will show that the call has emanated from that number to this number. To to that extent, it is admissible. But whether you made the call to me is a matter of evidence. That is the difference.
No, but in this case, as you say, hashtags, the brother next to you told, who will do that and let us know?
The Information Technology Act certifies certain individuals as experts in electronic evidence, which is what I said at the outset. Though the Act, Information Technology Act provides for an expert, the Evidence Act does not define who an expert is and does not borrow that particular definition from IT Act. Whereas most of those gimmicks and changes, like a computer which is used by an individual is renamed as a standalone computer. That is again borrowed from the IT Act. A portion of things which are required have been borrowed, but a portion of things which again relies on IT Act 2000 have not been borrowed. That is our grievance here.
So WhatsApp screenshot is
not worth the paper it's printed on.
Because of the encrypted nature.
encrypted. And WhatsApp chat is also has no evidentiary value as per Supreme Court.
Only in movies.
Thank you very much, sir.
And that's where this aspect comes in, the opinion of expert. It's a relevant fact. So when the court ultimately processes all the relevant facts and then ultimately comes to a conclusion, the fact that that opinion of the expert becomes relevant is provided for in the court.
In a lot of scenarios in movies or serials, you see the magistrate himself comes, hides, sees the proceedings and goes back and delivers the judgment. That is not done. Because even if the magistrate sees it, he has to recuse himself from the case practically, go in as a witness, put his career at stake, and then give evidence. There is no way he can be witness for the own case, for the very same case for which he is being a judge. So these are things that is only taken for the entertainment value. In reality, Evidence Act applies and that seeks to set aside these kind of issues and anomalies that can creep up in the society.
So to conclude, I would just like to say thank you so much to all the panel members. It has been a wonderful experience for me moderating this particular session, and I believe it has been a wonderful experience for all the audience members here present and listening to us talk about evidence and get into the nitty-gritties of the newer laws. So with that, again, thank you so much, and I would like to request again a round of applause for us.
Thank you, panelists. I think that was a very interesting session about what's really changed and what did not seem to have actually changed. Now, I request Dr. Shendragavali, Associate Professor at Vinayaka Missions Law School, to felicitate Mr. T. Gaudaman. Thank you. I now request Dr. Nyaya Sanhita, Assistant Professor at Vinayaka Missions Law School, to felicitate Advocate Mr. Nitesh Nataraj. Thank you. I request Ms. Rashmi Yesudas, Associate at Surana and Surana, to felicitate Mr. Nishant Shekhar. Thank you. I request Dr. Krishna Kishore Padala, Assistant Professor of Law at Vinayaka Missions Law School, to felicitate Dr. N.K. Mehta. Thank you, panelists. I now request Dr. Anand Padmanabhan, Dean of Vinayaka Missions Law School, to deliver the vote of thanks.
Thank you so much. in the beginning and now you're seeing me at the end. Thankfully, this is one of those rare occasions where the room is as full in the end as it was in the beginning. That speaks a lot to the caliber of speakers that we had today, the quality of conversations, and I think so. Therefore, it really is this on me to first begin by thanking the wonderful speakers that we've had through the day today, all different panels, including the last one. Amazing set of conversations and discussions. So I really am thankful to every one of them. I'm not going to name them, but starting from the first panel moderated by Shri Kalyan Jabak to the final panel moderated by my colleague Professor Ishan. Every single panel, I thought, brought out some new texture, some new complexity to these new laws. Clearly, I can see that there's going to be a lot of work for lawyers, and I can also see that for clients, this is going to not be as easy as has been portrayed. Of course, there are a lot of great measures out there that the new laws try to bring in, but there are going to be a lot of challenges as well. But then